On contempt case, another requisition will regarding midday meal rice meal of LP school. So it may come on second meal.
No, let it come on 6th.
Right, please, Lordship. Lordship, in item number 18 and 19, Lordship, we are going to file our affidavit today. We are filing it. In fact, ready, Lordship. So, Lordship, and there are some.
Let it reach.
15, 17, 18, and 19, that is 19, 28, 29, 30, and 30 are all same matter.
Lordship will fix some other.
17, 18, 19, and 31, they have yet not filed the affidavit, they will go they're filing today. Therefore, the all matter maybe come on 24th of September. In the meantime, we exchange our pleadings.
Okay, 17, 18 and 19.
18 and 19, today we are filing.
Okay, heard Mr. B. Barrow.
PP will go, yes.
For the petitioners. 18, 19, huh?
17, 18.
Mr. B.N. Sharma, learned standing counsel,
Elementary education department.
elementary education submits that he's filing counter affidavit within the course of the day. So accordingly, please take matter on. When do you want?
24th of September, Lordship. And these are the similar matters, Lordship. 24th September.
28, 29, 30.
How about 17?
17 also.
17 also.
Yes, 17, 18, 19,
28, 29, 30.
and 31.
And 31.
You are filing your affidavit 17?
In the 8.
31, they have not filed.
1 minute.
Only 31 we are going to file. The rest we have filed already.
Okay. Then
Sir,
heard
thank you.
B.B. Barrow and counsel for the petition on request made by B.N. Sharma, the standing counsel, elementary education, list on 24th, no? And then the other one,
24.
other one, item,
At 28, 29, 30,
And 31.
and 31.
okay, heard Mr. B.B. Barrow and for the petition. On request made by Mr. B.N. Sharma, then standing counsel, elementary education, Mr. Macron, 24th.
24. All the same matter, same argument.
Similar matter, Lordship. Not obliged.
Obliged.
Very please, Your Lordship. I recommend also this matter relating to my according approval to the newly constituted school managing committee, my lord. The one has already been passed, my lord. The matter was last listed on 12th August, but not reached, my lord. Or maybe on Friday, my lord. For orders, my lord.
Orders?
Order. For admission, my lord, because services are completed, my lord.
Maybe, Lordship. I beg to mention for listing for motion, Lordship. It is pending in the motion stage since the month of March, Lordship. On 1st March, it was listed earlier, and is directly respondents were directed to take instruction, Lordship. Matter may be listed, Lordship.
Okay. 6th.
May I please, Lordship? I beg to mention.
6th. Obliged, Lordship.
I beg to mention two admission matter, my lord, on first week of September, my lord.
If
Similar player, Lordship, right? If it's content matter, Lordship.
9th.
May I please, Your Lordship? I beg to mention a matter for listing more motion, my lord. It was filed on 3rd, my lord. Thereafter, it was listed on civil bench 3, my lord. It is matter pertains to civil bench 2, my lord. May I pray, my lord, it may come up on Friday, my lord. Obliged, sir.
May please, Lordship. Lordship, I beg to mention for listing this case on 3rd, my lord.
Which matter?
Matter relates to provincial legislation, contempt matter.
Contempt?
Earlier listed but not raised, my lord.
Okay. 5th.
I'm
May it please, Your Lordship. Lordship, with your Lordship's permission, I beg to mention this unlisted item in a writ petition. The urgency is that I have been continuously serving since 2008 in the THB college as junior assistant. Recently, on 7/6/2024, has issued a notification appointing me provisionally for a period of 89 days. And tomorrow the date is going to end. So I have the apprehension that I may be ousted thereafter. So that circumstance, I may be allowed to move this. Obliged.
May it please, Your Lordship. I beg to mention item 24 of the daily list, Lordship.
Yes.
My senior is out of station. Can a matter kindly be adjourned for the day? We have already taken the consent from the other side.
Okay, on request made on behalf of Mr. M. first, then the counsel for the petition. When do you want? After
May-
2 weeks.
Like,
List of the.
Hey, please, Your Lordship. I pray for listing a motion matter on tomorrow, Lordship. Similar matter is listed on tomorrow, Lordship, regarding Dorpon portal. Oblige Lordship.
May I please, your Lordship? Lordship, I beg to mention for listing of a contempt matter regarding provincialization of services.
9th.
Much obliged.
Please, your Lordship. I have to mention for listing orders matter. Lordship, the
11th.
matter was
11th.
posted.
11th. 11th of September.
May please.
Yeah.
Lord, I beg to mention item number 8. We were supposed to file an additional affidavit as per your lordship's direction. Lordship will give us 1 week time. I'll inform the petitioner council.
You have informed?
Yes, she's there for.
Okay. Third MS.
S. Patwari.
Patwari and counsel for the petition.
Lordship, date may be fixed.
On request made by Mr. B. Kaushik, Standing Council, Elementary Education Department. 1 week time.
1 week.
Date
Is
may be
allowed to
fixed.
file counter affidavit. List down. 3, 4, 27. 5th.
Can it be 6th one? Can it be 6th?
6th.
Oblige.
May please, your Lordship. Need for listing and admission matter, your Lordship. Matter is pension. Friday,
11th September.
another pair, your Lordship. Item number 35.
Oh,
As per instruction, I allowed to withdraw this petition. I have made a mention for withdrawal, but it is listed as a orders column.
Mr. S. Islam, Learned Council for the petitioner, press for withdrawal of this petition. Simple withdrawal.
Simple withdrawal. Oh, 35.
MS.
I'm appearing
He
for
does
secondary education,
Learners
1, 3,
Council.
4, and
Appeals for the
Right.
secondary education department. With petition is dismissed on withdrawal.
Oblige.
DPO.
One of daily motion. My please, Lord. My Lord, on the last occasion, although interim is granted, my Lord, but notice was not issued. So, my Lord, notice may kindly be issued in this matter.
Yes, Fukan.
Lordship, notice have been issued, my lord. And my lord, I have received a report, my lord, which I would like to submit on the last occasion. The court had directed me to get instructions. My lord. Lordship, I can bring it in the form of an affidavit. I will just like to show it once. It's a
Okay.
detailed report, my lord, actually. Summary LPS code. Summary,
Okay, you file your
I understand.
third, Mr.
Raman.
A. Raman, Learned Council. Issue notice. Mr. A. Fukan, Learned Standing Council, Elementary Education.
Issue 1, 2, 4, 5, and 6.
Appears for respondents 1 to 6.
No, my lord, 3 is for he's appealing. 3. What is
Okay, 1, 2, 4, 5, 4, 5, and
6.
And Mr. G. Bekul and Governor Cricket appears for the response number 3. Petitioner will take steps for service of notice on the respondents 7 and 8 by registered proceeding within 1 week. So, extra copies,
Interim may be continued.
respondents are not collected. This is the matter of the 4 weeks. Interim order for earlier to continue till the next meeting.
Much obliged.
Need to have supplementary motion.
Whether today is fixed for obtaining instruction by the standing council property.
Lordship, make an adjournment for the time being, Lordship. My senior counsel is on the way. By today only we have received the instruction, so
Let him come. after some time.
Wait, please. I am praying for implement of the page 30.
Implement of party.
My lord, page 3, my lord. Respondent number 4, 5, 6, 7, and 8, my lord. Because my lord, without their presence, my lord, this case may not be decided.
In the review,
In the review.
anybody appearing?
My lord, it is the state respondent, my lord.
Elementary?
L. Fukan is appearing, my lord. I think she's on leg somewhere, my lord. Matter may be taken after some time.
No, this is an implement of party.
Oh, in party.
You have any objection?
No objection.
Okay, heard Mr. I second, let's also for the petition. For the applicant. Stop. By this application. The applicant, who is the review petitioner, is praying for implement of, then you put Roman 1, 2, 3, 4 in page 3, A to A. As party respondents 4, 5, 6, 7, and 8 in review petition number 96 of 2024. On the ground that without the implement of the aforesaid response, this court, on the ground that the implement of the aforesaid respondents are necessary for adjudication of the said review petition. Mr. A. Fukan, learned standing counsel elementary petition has no objection. Para, this court has also considered the portion of the present application. And accordingly, the prayer for implement is allowed. Stop, I is disposed. Then in the main review, you say in view of the order passed today, I number so and so. Let again you put 1, 2, 3, 4, 5. Huh? The implemented as party respondents number
4, 5, 6,
4,
7,
5, 6,
7, and 8.
7, and 8 in the present review. Stop. Who are those?
Secretary Finance, Director of Secondary Education, Inspector of Schools.
Finance, anybody appearing? Mr. A. Chalia, Leonard, Standing Counsel, Finance Department.
I
Appears for the respondent, newly implemented respondent number 4. And secretary,
my lord, B. Kaushik.
Mr. B. Kaushik, Leonard, Standing Counsel, Secretary Education. Appears for the respondents 5.
5, 6, and 7, my lord.
5 for
Five-
the newly implemented
5 and 6, my lord.
respondents. 5, 6. Block elementary is also there.
My friend,
My lord, 6 and 7 I can appear. And 5, my lord, the B. Kaushik will appear.
Okay, then Mr. B. Kaushik, Understanding Council Secretary Education appears for the newly implemented
5 and
respondents.
5 and 6, because
And Mr. A. Fukan, Understanding Council Elementary Education appears for the newly implemented respondents 6 and 7. Stop. You'll have to take steps then.
my lord.
The petitioner to take steps for service of notice on the newly implemented respondent number 8 by registered post within 1 week.
Will go.
List the matter after 4 weeks.
The still
In the meantime, the review petitioner shall file an amended post.
my
Deeply.
Work daily admission.
My lord, this is regarding the official. Affidavit has been filed, my lord. That is on record. Lordship may kindly peruse the affidavit. My lord.
Where's Chitia?
Item number 2.
Affidavit filed?
Yes, my lord, that is on record. It was filed on 9th of August, my lord. Flag, I think there is a separate affidavit filed, my lord.
Filed on?
Filed on 9th of August.
Yes.
Yes, that is on. Lordship, kindly see.
But where's Chitia? We'll take up after something. Let me.
Lord.
Three.
Lordship, before my line of Lordship, in this matter, uh, we require to file an additional, that affidavit already we have sent for vetting, Lordship. That is yet to come, Lordship. Lordship, I'm praying for a short day. As per this.
I have an objection because if your lordship observed the order dated 2/2/2024, it was specified that no further adjournment would be.
Yeah, that one is there.
And thereafter, on 2 occasions, they took time to file affidavit, your lord.
How long will you take?
Lordship already sent for vetting, Lordship. Next week, any date, Lordship?
1 week time?
Yes, Lordship.
Make sure you file your affidavit.
Yes, Lordship.
And lordship may kindly observe that they want to bring on record on what grounds I had been terminated. They already filed their affidavit in opposition. Thereafter, I filed rejoinder. Now they want to cover up, your lord.
Heard Mr. S.
Yes, they know.
Learned Counsel for the Petition. Mr. S. Sugada, Learned Standing Counsel, IIT Board, submits that the additional counter affidavit.
Additional affidavit, Lordship.
The additional affidavit has been sent for vetting. And therefore, prays 4 weeks time to enable him to file. Praise the Lord. You want a date?
Yes, your lordship, kindly. 12th.
5th.
Lordship.
Fifth August.
Much obliged.
My lord, I have been told that Mr. T. Sutia is not well. He has not come to court, my lord.
In this was not, he's not feeling well. So,
When do you want?
Lordship, can it fix on 10th of September? Otherwise, my lordship has already fixed some matters on 5th and 3rd in this court only, my lord. 10th of September, my lord. It is a hearing day, my lord.
Okay. But item 2.
Item 2, my lord.
Heard Mr. T. Chakravarti, Learned Counsel. On request made on behalf of Mr. T.C. Chutia, Learned. Additional senior governor. List the matter on
10th of September.
not Mr. T.C. Sutia maybe is on in the first list.
Government advocate name is already the.
Lord. Obliged, lord.
4.
May I please, your lordship. My lord, today itself I have filed a reply affidavit, my lord. It is not on the record.
You filed this morning?
My lord.
Let the matter be listed on Thursday.
Thursday, there will be some difficulty for the registry to place.
Then Friday, man.
We'll have it on 3rd.
But August, September.
September.
Yes.
Mr. B.K. Das, Learned Counsel for Recruitment, submits that he has filed affidavit to the counter filed by the
Respondent number 7.
respondent number 7 this morning. Stop. We used to do verify and place the symbol. You found it all. Please
Hello.
count it. 3rd September.
3rd September.
Obliged.
Very clear, your lordship. And also the matter relates to selection and appointment of
Assistant Professor Lordship. So what happened here, Lordship, affidavit filed by the state respondents, and I have also filed reply. But now they have disputed regarding the award of marks in teaching experience. So that is why at this stage, the record of selection of the governing body of the college, that may be called for. That record is necessary, Lordship. From the affidavit, Lordship, it is found that the record of selection is required, Lordship.
Of the respond number 2,
The college, Lordship, it is the Korim Pandit Dindayal Upadhyay Adarsha Mahavidyalaya.
no, affidavit in
Oh,
opposition.
yes, Lordship, the director higher, Lordship.
I respond number 2 is
Yes, two
higher
words.
education.
I filed reply also. They have disputed regarding the award of marks of 1.9 regarding teaching experience.
Where's the dispute?
Lordship,
Where's the dispute? Where's that statement?
Lordship, kindly come to page, the affidavit filed by the respondent number 2.
63.
Yeah, page 63. There is a difference of 1.9 marks. In that particular column, the selection committee already awarded 3 marks, but as per the respondent number 2, I was entitled for 1.9 marks. So that is why the selection record in the essay, Lordship.
Okay. Who appears for the?
No, sir. One and
No, but then the selection report will be produced by whom?
by the government, it is by the director here because the after recommendation, the matter has been sent to the director here for its approval. So selection record is there, Lordship. So from the director, the record of the governing body of the college, name of the college is Pandit Dindayal Upadhyay Adarsha Mahavidyalaya.
Okay, heard Mr. Dekal and the council for the petition.
1.9.
Mr. S. Buyan, the standing council higher division shall produce the selection report of the governing body of Pandit Din Dayal Upadhyay Adarsha Mahavidyalaya Iraligur. District Library. When can you produce it?
2 weeks after 2 weeks, Lordship.
Oh, you are appearing,
No,
not
sir.
Buyan. Okay, then you say, Miss.
No problem, Lordship.
Okay, go ahead. Huh? How much time?
2 weeks, Lordship, after 2 weeks.
Please.
Matter after 2 weeks. Oblige.
6.
Here, Lordship, this is the second round of litigation, Lordship. Lordship may straightway come to,
Counter has not come.
Lordship, without affidavit also, Lordship, matter may be disposed of.
Last time she wanted to file and this court granted 1 week time.
Lordship, although the instruction is received, Lordship, may I place the instruction?
No, last occasion also she submitted that she received instructions
Lordship,
and she wanted to file an affidavit. It's up to you if you want to file your affidavit or not.
Lordship, grievance of the petitioner is that he has been serving as a casual employee in a senior basic school. And thereafter, he has been paid the fixed pay of salary up to 2016. Thereafter, not paid. Now, in the first round of litigation, my claim that in view of the Upendra's judgment, if I am entitled for the minimum pay scale, so accordingly, matter was disposed of in view of the Upendra's judgment. Lordship, that is why kindly state will come to page 74, annexation 19. The grievance as well as the direction Lordship will find. But while passing this impugned order, the judgment of Upendra is not at all considered. Lordship, kindly come to page 75. From paragraph 3, may I read, Lordship? The petitioner claims that the petitioner was initially appointed on 13/10/1987 as a Chowkidar grade 4 employee by the managing committee of so-and-so school under Bihpuria so-and-so. The petitioner had been receiving fixed pay of salary at the rupees 900 per month from the date of appointment till September 2016. Although the government had enhanced the fixed pay salary of such employees in terms of the WAME issued by the Finance Department from time to time. As per WAME dated 29/2004, fixed pay was enhanced at the rate of 1800 per month. Subsequently, another WAME enhanced the fixed pay salary of casual employee from 1800 to 2100. However, The petitioner continues to get the fixed pay of rupees 900 in spite of enhancement of the fixed pay. It has been submitted that subsequently government issued another WEM 15 to 2006 by which fixed pay has been revised from 22,100 to 2,500 per month with effect from 1/3/2006. The Learned Counsel for the petitioner submits that subsequently there has been another revision of the fixed pay and is up to 4,500 in terms of the order passed by this court in writ appeal number 45 public 2014, which was disposed of on 8/6/2017 in the case of Upendas and others versus State of Assam. Learned Counsel for the petitioner submits that the state government has already agreed to pay minimum pay scale attached to the post of grade 4 to those who are not regular employees but who were appointed prior to 1/4/1993, and accordingly stated that such employees have been given the said minimum pay scale 4,500 per month. In view of the above, the state respondent also submits that the authority will examine the claim of the petitioner and pass appropriate order for enhancement of the fixed pay. So this is the grievance of the petition. Now, penultimate paragraph. In view of the above, the present writ petition is disposed of by directing the respondent authorities, more particularly respondent number 1 and 2, that is the commissioner and director, to verify the claim of the petitioner, and if it is covered by the aforesaid order passed by this court in writ appeal number so and so, he may also be granted minimum pay scale of grade 4 within a period of 3 months from the date of receipt of the certificate copy of the order, along with the copy of so and so, as well as annexes to this petition. As regards the claim of idiot, same shall be granted in terms of this direction of this honorable court. Now, Lordship, kindly come to page 77 and Annex 20. This is the impugn order. Now, while issuing this order, Lordship, the direction of the court is not at all discussed. The grievance of the petitioner is not considered by following the Upenda's judgment. Peruse, Lordship. Page 77, Annex 20. The Honorable High Court, this is the direction, Lordship. Also, peruse the Honorable High Court 8/6/2017, passed the written number so and so. In para 20, now read, Lordship. Read the government letter number so and so 17 to 2022, wherein it stated that as per Assam Elementary Education Provincial Service Code 1974 and 77, school managing committee is not the competent authority to appoint against any post either teacher, official staff in a provincialized or gov school. It is also stated in the aforesaid government letter that the petitioner Basudev Deuri was appointed by School Managing Committee of Deomornoi Junior School in the year 1987, though the appointing authority of the Director of Elementary Education Assam and instructed to pass a suitable speaking order accordingly. Seen the inquiry report submitted by the district level inquiry committee, Directorate level inquiry committee constituted to examine the claim of Basudev Deuri, the petitioner of contempt so and so, arising out of WBC so and so, wherein it is stated that the petitioner Sri Basudev Deuri was appointed by the school managing committee as honorary casual employee at Mornoi Deuri Government Junior Basic School in the year 1987. It is also stated that in the inquiry report that no formal appointment letter was issued in the name of petitioner from the appropriate competent authority, and the school managing committee is not the competent authority to appoint any type of post in government school. Since the so-called appointment order of Basudev Deuri, it was signed by the headmaster of the school as per resolution of the managing committee of 13/10/87. Now, decision. Mornoi Deuri Gov Junior Basic School is a government school established by the government. The appointing authority of teaching, non-teaching staff in government school is the Director of Elementary Education Assam. The school managing committee of government school is not the competent authority to appoint any teaching, non-teaching staff. Hence, the so-called appointment letter of Basudev Deuri is not valid. The claim of the petitioner is hereby rejected. Now, accordingly comply. Now, so here kindly see the nature, they are going to the root of the appointment. I am not claiming here for any regularization, Lordship, my service. My claim is for as a casual employee, whether I am entitled for the minimum pay scale or not. But since 2016, they have paid the salary. Now from 2016 onwards till the date of my retirement, they have not paid my minimum pay scale. That was the grievance. And accordingly, case was disposed of in terms of the offender.
When did you retire?
Lordship in 2022, Lordship.
Date?
Date, Lordship. I will submit, Lordship. Right now, I don't have. In 2023, retired.
Okay.
Now,
What-
in view of the, it is from the apparent Lordship that they at all not consider the direction passed in the Upendar's judgment. Here they are merely saying that I am appointing by the managing committee. True. That is why I am an honorary casual employee. Now, question arises whether casual employee is entitled for the minimum pay scale or not. Now, as if we go by the division bench order with appeal, I am entitled, Lordship. And that direction is not at all considered by the director.
Yes,
wanted-
Sharma, this, you are going on the basis of his regularization. The
Lordship.
petitioner is not claiming for regularization, he is just asking for the minimum skill
Minimum
pay.
skill, Lordship.
And Lordship kindly come to page 38 annexure 8.
Direct.
You reconsider the case of the
Yeah.
petitioner.
Consider, Lordship.
This order may be interfered, Lordship.
But Mr. A. Dekal and
Also, prior to that also, the annexure 8, page 38, annexure 6. These are the letters or communication whereby I have been paid. Annexure 6, page 38. Type copy, Lordship. Sanction for payment of casual employee. Page 38. So thereafter I received page 40, Lordship, 10,800 I have received. Now come to page 40, annexure 7.
which
If page 40, annexure 7. After this proposal, the name of the petitioner Lordship finance serial number 3, Bahudev Deuri. Amount required 10,800. This amount also received. So there is what I would like to submit, that there is no dispute that I have not received the fixed pay amount. It is they also admitted up to 2016 I have received the amount fixed pay of rupees 1,800. But claim is for minimum pay scale in view of Upender judgment. That is my case, Lord.
Lordship, direct to dispose of.
what Mr. A. Dekal and
If entitled, verify and if entitled.
also heard Mr. B. N. Sharma and the standing
In
counsel.
view of it,
In view of the record. And in my instruction may be based on record.
Elementary Education Department. For the respondents, 1, 2, 4. Finance. Mr. Chalian and the Standing Counsel Finance Department for the respond number 5. Anybody, Headmaster?
well, notice sir, but nobody is appeared.
Para. The case of the petition is that he was initially appointed on 13/10/1987 as a chokidar, within bracket, grade 4 employed by the school managing committee of Mornoi Deuri Government Basic School, Bhagara, under Viburia Educational Block in Lakhimpur district. Stop. Thereafter, the petitioner was paid a fixed salary at the rate of rupees 900 per month from the date of appointment till September 2016. Stop. Learned counsel for the petitioner supports that by OM dated 29/2004. Who is that OM?
I'm not sure.
Who is your list of dates?
I'm not sure. Annexure 18, page 73. After Upender judgment, this was issued, notification is issued. 8th of March 2019. Page
Oh.
73.
What is that by OM dated 29/2004. The fixed pay was enhanced at a rate of rupees 1,800 per month. Stop. Further by another OM. The fixed salary of casual employees were enhanced from rupees 1,800 to 2,100 per month. Stop. However, the petitioner continued to get the fixed pay of rupees 900 in spite of the enhancement of the fixed pay. Stop. Thereafter, further, comma, the government issued another OM dated 15/2/2006, by which the fixed pay has been revised from 2,100 to 2,500 per month with effect from 1/3/2006. Stop. What is this OM page 73?
Page 73. This is the office memorandum issued by whereby the minimum pay scale has been granted by the Finance Department after this Upenda judgment. The following are hereby notified. Sorry, watching that. In compliance with the state government department
I
as
don't have a type copy.
that copy is not given, let's see.
Thereafter, comma, the Commissioner and Secretary to the Government of Assam, Finance Department, by a notification dated 8 March 2010.
19.
19 Lord Sir.
Huh?
19 Lord.
2019.
Lordship, if I may, Lordship, there's a subsequent to this, when there was another notification in where there's certain changes because in here house rent allowance and all were included, there was a slight modification. That notification has not been annexed over here.
Where's the, where's the,
Lordship, that I can get, my lord, it was issued in October, Lordship. That's 2019. It was in modification of this OM. This is not, that has not been annexed.
Modify good.
October. Here the
Whatever.
house rent allowance mentioned, Lordship, which has been struck off in the.
then you cancel that list.
Learned
Learned Counsel for the petitioner also supports that subsequently there has been another revision of fixed pay by enhancing to rupees 4,500 in terms of the order passed by this court in writ appeal number 45 of 2014, which was disposed on 8/6/2017 within bracket Obindas and 825 others versus state of Assam and others. However, comma, as the petitioner was not given the minimum skill pay, he approached this court by filing WBC number 5615/2019, which was disposed of by order dated 7/8/2019. And the operative portion reads as on page 76, 8 to 8. Stop. But thereafter, the Director Elementary Education Assam passed in the order on 28th February 2022. And the relevant portion reads as under page 77, B to B. So, para, learned counsel for the petitioner submits that a perusal of the order dated 28 February 2020 clearly indicates that the case of the petitioner was not considered in terms of the directions passed in the case of Ovindas within brackets stop. And therefore, reconsideration of the case of petitioner is stop. He also submits that the petitioner retired
In the year 2022, exact date, Lord, sir, I will
in the year
provide.
2022. And the petitioner is not praying for regularization of his service,
Yes.
but only for grant of the minimum scale of fee
As well as the area amount, Lord, sir.
as well as area amount in terms of the directions passed in the case of Ovindas, within bracket Supra. Stop. Para Mr. B.N. Sharma, Learned Standing Council Elementary Education Department submits that the petitioner was appointed by the school managing committee as an honorary casual employee at Mornoi Deori Government Junior Basic School in the year 1987. Stop. The appointing authority of the teaching and non-teaching staff in government school is the Director of Elementary Education Assam. And the managing committee is not a competent authority to appoint any type of, to make any appointments to any type of post in government school staff. However, as the petitioner was appointed by the school managing committee in a government school, his appointment is illegal and in contravention of the rules and procedures issued from time to time by the government of Assam. Therefore, the question of regularization of the service of the petitioner does not arise, and the government has already rejected the claim of the petitioner for regularization of his service by a speaking order dated 17 to 2020.
28 February 2022.
It's 77.
77.
By the order dated 28 to 2020. Stop.
In compliance to the writ petition.
Yeah. Stop. A consideration of the order dated 28 to 2022 clearly indicates that the case of the petitioner was not considered in terms of the directions passed by the division bench of this court in the case of Ovindas within the Supra. Stop. Further comment. The petitioner is not praying for regularization, but only for grant of the minimum scale pay in terms of the directions passed by the division bench of this court in Ovindas Supra. Stop. Para stop. There's no discussion of the case of the petitioner with regard to his eligibility for the minimum basic for the minimum scale pay in terms of the directions passed by the honorable division court. Honorable division bench in Ovindas Supra in the order dated 28 according to the order dated 28 to 2022 is set aside by the boss, and the matter is remanded back to the Director Elementary Education Assam to have a re-verification of the case of the petition and thereafter we have a re-verification of all the documents of the petition and thereafter pass an appropriate order in accordance with law with regard to the eligibility of the petitioner for being granted the minimum scale pay along with areas if found if the petitioner is found entitled to the same. So let such exercise be done and completed within the period of
2 months from the date of receipt.
2 months from the date of receipt of a copy of the order.
In page 38 and page 40, these are the proposal lordship. Let me all be indicate lordship. Page 38, sanction for payment.
Just in my directions, no? This court has also considered the proposal of the proposal of the deputy inspector of schools.
This is the list of casual employees
Not
for whom this amount is required. So
Well,
accordingly, proposal submitted.
where a list of casual employees
Page 40.
working in different government junior basic schools since 1983 and has been receiving payment within bracket fixed pay up to March 2003 at a rate of 900 per month. Stop. Furthermore, on the basis of the said proposal, where is the petitioner's name?
My name, lordship, in the list, serial number 3. Basudev Deuri, page 40.
In the sections.
At that element, the
The name
requirement
of
is
the
10,000
petitioner
800.
appears at serial number
3.
3,
Basudev Deuri.
Vasudev. And the amount required is shown as rupees 10,800. Learned counsel for the petitioner submits that the said amount of 10,000 rupees, 10,800 has already been paid to the secretary. Huh? Because they don't have the corrected notification. Okay, this I'll incorporate later on when I make the correction.
Much having. This verification process will take perhaps some time. Lordship may 3 months may be granted.
60 days ago already.
90 days perhaps will be required. So, in a period of 90 days.
Make it 3 months.
3 months.
Deplorable.
7.
Matter relates to payment of death cum retirement gratuity. Only this matter can be taken up for disposal. Here, admittedly, the petitioner was appointed in the year 2010, and he is covered by the new pension scheme. And under the new pension scheme, the payment of death cum retirement gratuity, that was not there, that provision was not there. But thereafter, by an notification in the year 2018, they extended the benefit to those employees also who are not who are covered under the new pension scheme. And as such, he applied. But here, by the affidavit filed by them, we have come to know that they have not released my death cum retirement gratuity because I have not, it seems, contributed my share of my salary towards that scheme. That is what they say. But perusing the new pension scheme and the guidelines that is there, it shows that it is the responsibility of the drawing and disbursing officer as well as the authorities for generating the permanent account number and thereafter calling for the details of the employees and thereafter deducting the employee's contribution from his salary. Now,
But then is it admitted that you have not contributed?
that is admitted.
Then
That is
how can you
admitted.
get it?
No, but it was their responsibility to generate the permanent account number and deduct it from my salary.
That they have
The
not
drawing,
done.
that they have not done. I cannot, it's not me who draws my own salary. Lordship, it's a drawing and the authority is concerned and the drawing and disbursing officer who releases my salary. It's credited to my bank account. It's for them to deduct. The pension scheme clearly formulates everything.
Let
How
us
it
see
is
this.
done. Lordship, if your Lordship takes up this book, Assam pension, for this Assam pension. Service.
Yes.
Lordship pays 312 there.
Yes.
The scheme is their appendix A, new defined contribution pension scheme. And I'll just read out the relevant salient features. Serial number 2, salient feature, in tier 1, the government servants will have to make a contribution at the rate of 10% of his or basic pay plus DNS allowance, which will be deducted from his or salary bill every month by the drawing and disbursing officer concerned. The government will make an equal matching contribution. Then the next relevant feature, serial number 8, the next page, Lordship. The deduction of employees' contribution for the new defined contribution pension scheme in respect of government servant joining state government services on or after 1/2/2005 will be effected from the salary of the month of January 2010. And serial number 10, necessary permanent pension account number will be issued in favor of each employee for crediting their contribution along with state government's matching contribution. These may be confirmed by every DDOs prior to the deduction of contribution. Now, these are the relevant salient features. If your Lordship turns to the next page, the guidelines for implementation of the new defined contribution pension scheme is provided there. I'll read out the relevant guidelines, which is relevant to our case. Serial number 5. It is mandatory for all such new employees mentioned above who are recruited on or after 1st February 2005 to become members of the new scheme. Next, if your Lordship takes up serial number 10, next page, facing page. In tier 1, the government servants will have to make a contribution of 10% of his or her basic pay, DNS pay, if any. DNS allowance plus non-practicing allowances which will be deducted from his or salary bill every month by the drawing and disbursing officer concerned. While calculating 10% of basic pay, DNS allowance plus non-practicing allowance, etc., the fraction of a rupee to an extent of rupees 0.5 paise and above may be rounded off to the nearest rupee. Fraction below 0.5 paisa may be ignored. The government in turn will make equal matching contribution to the tier 1 through the Director of Accounts and Treasuries Assam from grant number 13 out of the provision made under 207 pension and other retirement benefits 117 government contribution for new defined contribution pension scheme after issue of necessary sanction. The next serial number 11, the contribution towards tier 1 cannot be withdrawn till the date of superannuation or the date of leaving the scheme before attaining the age of superannuation. Serial number 12, the contribution towards new defined contribution pension scheme in respect of such employees shall be recovered from the salary through pay bills. So Lordship turns to the next page, serial number next, the details are serial number 17, 18 onwards. Immediately on joining government service, such government servants will be required to provide particulars of their names, designations, scale of pay, date of birth, nominees for the fund, relation of the nominee, etc. in the prescribed form in triplicate in Annexure 1 to the DDO concerned. The DDO concerned will be held responsible for obtaining these information from all such government servants covered under the new pension scheme and forward a copy of the same to the head of department, head of office, as the case may be, who maintains the records. The DDO concerned will retain a copy with him and another copy will be sent to the Director of Accounts and Treasuries, Assam, along with Annexure 2 by the DDO concerned directly for allotment of pension payment account numbers. The Director of Accounts and Treasuries, Assam, being the nodal office, will maintain the account for the new defined contribution pension scheme. Permanent account number will be allotted to the employees who join the new defined contribution pension scheme by the Director of Accounts and Treasuries, Assam, on receipt of information from the DDO concerned in prescribed form, annexure to this scheme. Permanent pension account number for government employees and teaching and non-teaching employees of provincialized educational institutions, as well as those of panchayat, will be separate type or series. We can skip over serial number 19. If we come to serial number 20 now, The Director of Accounts and Treasuries Assam, on receipt of information in format at Annexure 2 from the respective DDOs, shall put in the particulars of the government servants into the computer system. The system will generate a permanent pension account number for each of the government servants and keep a separate ledger account for each member of the scheme as per format at Annexure 5. The system will also maintain a consolidated ledger in format Annexure 2 in the computer as well as in a register separately. So, at least from these lordship guidelines, it's clear that it's a DDO will have to collect the particulars from the employee concerned and forward it to the Director of Treasuries and Accounts, who will feed it into the system and generate the permanent account number. So obviously, it's clear that in my case, that has not been done. And for that, I cannot be deprived of. And what about the government contribution?
So when you have not contributed, the government will not contribute.
No, Lordship. First of all, there has to be a permanent account number. And for
That has not been opened against you.
for that, it is the DDO concern who is, it's clear from the guidelines here, who will have to collect my particulars.
That's
We'll have,
true,
yes,
that's true.
yes,
The DDO
Yes.
did not collect your particulars.
yes,
And did not send it to Director of Pensions.
yes.
And accordingly, since those particulars were not forwarded to Director of Pensions,
At least that is what it
you're
appears.
not given that account number, correct?
That is what the affidavit says, that the permanent account number has not been opened. So
Exactly.
far as whether the DDO had collected for, so far as the petitioner is concerned, it seems he had collected, when the DDO was initially not made a party in the writ petition. Thereafter, we got him impleaded. Now, if he has collected, what did he do with the particulars? Obviously, he had forwarded it to the
Where's,
that
who appears for DDO?
that details we do not have.
No, no.
Because in the affidavit that these
Who's
This
the
has not come.
respondent? DDO?
DDO Lordship, later on, we have made him respondent number 9.
Respondent 9.
9. A notice has been sent to him. He has services complete on him.
Headmaster.
Yes.
Anybody appearing? No. Notice is complete.
Yes, service complete. Service complete. Only BTC council will appear.
No, he cannot appear for the
He's
headmaster.
the headmaster of the provincial school. Lordship.
Maybe a provincial school, but then the BTC authorities cannot appear for the headmaster.
But service is complete on him. We have taken the steps requesting. It is complete.
See, according to the BTC authorities, the DTO has not submitted the particulars.
That is that they do not say. They do not. The affidavit does not say that video has not submitted the particulars. Affidavit simply says that there is no
Let us see the.
affidavit. Affidavit come on. BTC affidavit. Respondent number 3. It was filed. File person.
Yes, I want that.
Serial number 42. It seems 42 onwards. At page 44, what he says, last paragraph, it is further submitted that though by the office memorandum number so-and-so dated 1st of February 21, the employees who joined service on or after 1/20/2005 are entitled to retirement gratuity and death gratuity. The present petitioner is not entitled to such benefits because of the fact that he had not deposited his monthly subscription amount. Lordship, page serial number 44. The affidavit
Serial number?
44, page 44. 44, second paragraph. Continuation of paragraph 3 of the affidavit filed by the respondent number 3, Director of BTC, Director of Education, BTC. Has the Lordship got it?
Yes, yes.
Last paragraph, the present writ petitioner is not entitled to such benefits because of the fact that he had not deposited his monthly subscription amount under the new defined contribution pension scheme from the date of his joining till his retirement. He did not even open a permanent retirement account number and a permanent pension account number in concerned Treasury Office under the new defined contribution pension scheme. Therefore, he could not avail the retirement gratuity and get that gratuity benefit in terms of the office memorandum dated 1st February 2000. That is what is only stated in the affidavit. It is not, I cannot open a permanent pension account number. That is what.
Was it not your duty to have also at least inquired?
No, Lordship, it is for the, it's the scheme clearly says. It's
No,
the
no,
DDO
scheme
concern
clearly
who has to
says that.
collect.
That is fine. It is the DTO who is responsibility to collect your details and
Yes,
then submit it to the director of pension.
yes.
But at least you could have also inquired with the DTO whether your pen or PRAN was opened or not.
Lordship, of course, he had inquired, but unless and until the authorities.
Yes,
Uh,
Nayak,
Lordship, we have clearly taken our.
no, that I've seen.
Lordship. And that is why Lordship DDO was made party. Under what circumstances his permanent account number was not open. So let the DDO come, Lordship, he will.
Yeah,
explain.
DTO will have to come.
Lordship, please, service is complete. No one has entered appearance on his behalf. Lordship will,
The petitioner to express step, Lordship.
no, what fresh steps? Lordship, this person has retired in the year 2008. He'll go on
Lordship will
taking.
consider
What
a
is this?
person who entered service in the year 2006, continued till 2018. All others have permanent account number. This person does not have. But he is not concerned whether my personal account number has.
No, you cannot shift the responsibility on me like that.
Responsibility is also on the petitioner, Lordship.
That's the question this court was asking.
Lordship, that is why I am not objecting at this stage.
Lordship, let
The DDO come, Lordship, he will
Lordship,
explain.
let a personal appearance be given, Lordship, if after completion of service, if he has not cared to enter the appearance. Or through the director's office, they can communicate because he is an employee of the director under the PTC government.
Can you at least inform the DTO?
If board directs, Lordship, I can of course do that, but it will be better, Lordship, if the person comes himself, Lordship, engages somebody, Lordship. After all, headmaster, we do not represent.
Lordship,
Where is that notice?
Notice was issued on 18/12, Lord. 19.
You took dusty service.
yes, Lordship, we have filed the affidavit also.
Who is that affidavit of yours?
Page 47, affidavit
Page
47. Hmm? You can come.
No, page 47.
You can come, please. Lordship, 49 is the notice where the headmaster has received the copy of the honorable court's order. 49, he received it on 25/1/2024. 25th of January itself.
Where is that?
49. 49 is the notice where the
Where our paging is.
49 is and page 49 of that affidavit.
Okay.
25th of January itself. Lordship, through the BTC government, if they can communicate, obviously they'll be able to do it.
Third MS, the board go ahead and a consider. Stop. After hearing the matter at length, this court finds it necessary that an affidavit by the respondent number 9 oblique the headmaster of Kamal Singh MV School, Kokrajhar is required. Stop. However, despite service of notice, the respondent number 9 is yet to make any appearance. No affidavit has been stopped. Accordingly, the respondent number 9 is direct. Are you appearing? No. Respondent number 9 oblique the headmaster of Kamal Singh MV School, Kokrajhar is directed to appear in person before this court. Or we'll give him some time on 16th of February at 10:30 AM.
Lordship, February,
September.
16th September.
16th of September at 10:30 AM. Now, list the matter on 16th September.
Okay, the registry will communicate this order to respondent number 8. His address is there. So he, as he is not representing, he is represented by anybody, he may not be aware about this.
Registry is direct to forward a copy of this order to the respondent of the right. Forward.
8 Lordship, 8. That is the director. He is representing the director.
This is the respondent number 9. We're calling him.
Lordship, I'm appearing on behalf of Bishop, standing counsel AG. Respondent number 8, Bishop. Standing counsel AG.
Who's the respondent number 8?
Accountant.
Okay, on top you just put Mr.
He does.
He does. Then the council appears on behalf of Mr.
Sharma.
V. Sharma, then the standing council accounting general.
9.
With the Russians. Well, here, well, data pension, well, was well, data to and their affidavit, well. Well, matter family partners, well, non-payment of special family pension, well. Earlier, well, the petition had approached before this court, well, in the year 2015, well. The matter was settled by this honorable court, well, and court had directed the
1
respondent.
minute. Yes, Chitti.
And this school has already been amalgamated with the higher secondary school. That's why they have to amend the parties.
Which school?
Secondary education.
Huh?
They have made party elementary education, but secondary education is required to be a party because school has already been amalgamated.
My lord, in the year 2015, my lord, this court has already been directed, my lord. Can come to page 31, my lord. The operative portion of this order, my lord. Earlier order passed in the earlier petition, my lord. Page 31, my lord.
Yeah, this is
Yes, ma'am.
direction to the school education department authorities. So you'll have to take steps.
But the petitioner school is now under the secondary education department.
Why
My
not you
lord,
make-
school is not concerned, my lord. Here, my lord, what happened, my lord? The concerned authority, my lord, due to pension, my lord. He is to revise the.
see, Chitia, this
The
page,
director-
page 31.
Right.
The order is director of respondents in the education department.
Right.
There's no particular
Yes.
direction to elementary or secondary in the school education department. So you'll have to take appropriate steps in terms of your
So
order.
different that's why.
Maybe the director, but then the education department, it's education department, whether it's secondary or elementary. You take instructions,
Well, I have received the instruction,
then why you're not filing your affidavit?
but they have instructed it is under the secondary education jurisdiction. That's why they are not able to.
No, that's fine, that it has been already amalgamated. But then at least read the direction passed by this court at page 31. Then you
Okay.
take steps.
My lord, due to non-compliance of this order, my lord, contempt case was filed twice, my lord. And every time, my lord, the date of pension mislead the court, my lord, saying that no, we have
I am
already
not paying
revised.
for director of pension, I am paying for education department. Director of pension, government advocate is there.
Okay,
Well,
but let's have to run a council for the petition.
Government advocate, yes, sir.
MS, yeah, then it's standing council,
Elementary education.
elementary education,
My lord, date of pension,
Director of pension is party man.
date of pension is vital role, my lord.
and MS DD Burman and government advocate. Appearing for the respondent number,
4, my lord,
Four.
date of pension, my lord.
shall take instructions in the matter. Stop. When list after 2 weeks.
My lord, date may kindly fix, my lord, because my lord, petition is fighting since 2015, my lord.
It's on 13 September.
My lord,
10.
oblige, my lord.
In this matter, we were directed to release the current as well as area salary to the petitioner lordship. We have released the current salary now. We are working on the area part lordship. So some time is required lordship, for granting the releasing the area part lordship. At least 2 weeks time, maybe 2 or 3 weeks lordship. Current salary we have released.
Third, Mr. I. Cycle and the council. Mr. A. R. Tabildar and the standing council higher education submits that the current salary of the petition has already been released and the authorities in the higher division are considering the case of the petitioner for release of their salary. He therefore prays for,
3 weeks time.
I'll give you 2 weeks time. Prays for 2 weeks time to enable him to receive instructions. Praise the Lord. Please come for 2 weeks.
11.
Well, Lord, in this case, the governing body has filed an affidavit today, Lord. Today, no?
Yes.
So I would like to file a reply, kindly change the same maybe.
Who is appearing for government, governing body?
I'm appealing.
Heard Mr. Gain Chowdhury and the senior counsel. Assisted by Mr. R. M. Dekha, under the council.
2 weeks.
Mr. J. Bayam, under the council for the respondents, 3 and 5.
Yes.
Submits that he has filed an affidavit in opposition this morning. Stop. Registry to verify and place the same on report informed in order. Mr. Gain Chowdhury, the senior counsel, prays for how much time?
10 days time, Lord.
Prays for 2 weeks time. To file reply, to the counter filed by the respond number?
2 and 3.
2 and 3, Lord.
Or 3 and 5.
3 and 5.
3 and 5.
By the respondents, 3 and.
Lordship may kindly list the matter on 12th or 13th, Lord, September. 12th.
You want on 12 or
12,
13?
12.
12.
Lordship, the respondent number 2 has already filed on 14th of August.
Have you received?
Yes, yes, we have
Yes,
received.
Because they have brought up some certain factual aspects, so we need to clarify that.
Well,
Lord, the matter relates to a recruitment of grade 4 posts in LP and UP schools of Kachar district. Lord, this case has a checkered history. Now, if your lordship would kindly come to page number 38. In fact, before that, if your lordship would kindly come to page 34. Way back on 16th of December 2005. This was a communication by the Director of Elementary Education Officer to all the district elementary education officers. And if your lordship would kindly come to page 35. For recruitment of 504 grade 4 posts, of which Kachar, Milord, there were 48 posts. So in respect of the other districts, pursuant to the selections made, appointments have been made. But in respect of Kachar, my lord, till date, things have not crystallized. Now at page 38, as an order of this honorable court, the operative portion is at 39. Please come.
Before my learned senior starts, my lord, it is taken up for hearing, my lord, the affidavit of the finance will be necessary. In fact, my lord, my instruction of July 2024 says that, my lord, they have sought for some updated, my lord, information from the education department, which is awaited, because of which we have not been able to file an affidavit. Main ground is, my lord, though they have been found to be, my lord, genuine or so, my lord, initially. Subsequently, my lord, their appointment has been rejected by the government on the ground that, my lord, no SIU approval was there, my lord, at the time when the selection was made. Now they are taking a stand that, my lord, when the selection was made, my lord, there is no necessity of having a SIU approval. In fact, my lord, the selection process was initiated pursuant to a communication which was issued in December 2005.
That
There is a
that's
statement,
right.
categorical.
page 35.
Now, my lord, my information is this, my lord, that in July 2005, my lord, the SIU was instituted, it was constituted. Prior to that, my lord, there was SLEC. So since, my lord, the selection was held after July 2005, SIU approval for any appointment is necessary.
Then what
I will
about,
bring it
what
up.
about the other districts?
My lord, here it is confined to, my lord, Kasar
My lord,
district.
can I clarify this position, my lord?
SIU approval is required for what? What it was seen, my lord, earlier. Against one sanction post, 1,000 people were appointed. There are instances in Nalbari, in Sonipur district, it happened. So SIU approval, the purpose is, my lord, if there is one vacant post, then SIU approval will be for that vacant post. And the moment that post is filled up, there is no further scope of making any arbitrary exercise of power. Now, my lord, SIU approval in this case in respect of other districts were not there. Now, my lord, there are series of judgments. There are two judgments pursuant to which, my lord, lordship will see whether they have mechanically exercised power or not. It's very simple, my lord. There was a committee constituted by this honorable court. If your lordship would kindly come to that order, my lord, if your lordship still feels that SIU part, that finance department's part is required, lordship will definitely grant them time. Please come to, my lord, this order at page 63-9. The order starts at page 63. If your lordship would kindly come to page number 70.
Yes.
Somewhere in the middle, my lord, the sentence starting with in the speaking order. Yes. In the speaking order passed by the Director of Elementary Education, Assam on 22/12/14, in respect of Kachar district, it was held that 3 different consolidated list of candidates had been submitted by District Elementary Education Officer Kachar, and having regard to the same, the state level selection committee in the Director of Elementary Education had rejected the said list as the same were contrary to the guidelines issued from time to time. The said speaking order dated 22/12/14 also indicated that state level selection committee decided to re-advertise the vacant post of grade 4 in the government and provincialized lower primary schools in the Kachar district. This order dated 22/12/14 is put to a test in the present proceeding, and this court, while issuing notice on 7/12/16, also passed an interim order directed respondents not to issue advertisement to fill up the vacant grade 4 post. I have heard the learned counsel for the parties and have also perused the materials on record. This court is of the considered view that matter with regard to recruitment to grade 4 posts in Kasar district could have been dealt with in a more pragmatic way. Parties agree that there is no dispute to the fact that candidates, including the writ petition herein, had responded to the individual advertisement issued by the respective school, and they have also undergone the selection, having appeared before the respective selection committee, in which the District Elementary Education Officer Kachar was the chairman. The said District Elementary Education Officer Kachar must not only be aware, but must be having the various select lists of the candidates of the respective schools. On the basis of the individual list from the respective school, the District Elementary Education Officer can well prepare a bona fide consolidated list of selected candidates in order of merit as against the respective school. In this connection, N. Sharma also submitted that necessary records are required to be available in the office of the District Elementary Education Officer Kachar, and the exercise so indicated by this court can very well be carried out by the said authority towards appointment to grade 4 posts in the government and provincialized lower primary, upper primary schools in the district of Kachar. This, in the opinion of this court, would serve the interest of the petitioners and other deserving candidates, as it is only in respect of Kachar district that recruitment exercise has not yet been completed. An exercise as directed to be completed within 4 months from today. Needless to say that consolidated list is now to be prepared. Afresh shall be done in strict accordance with the merit of the candidates who appeared for selection before the respective screening committee of the respective school. To facilitate this exercise, the school authorities consult and extend full cooperation to the District Elementary Education Officer. All the writ petitions are disposed of. Now, my lord will kindly come to order dated page 72. With reference to the subject cited above, I am directed to request you to attend before the inquiry committee on 30th October 2018 at 12 noon to be held in the office chamber of the undersigned to inquire the interview process of grade 4 Chowkidar in Kachar district in compliance of the order dated 24/7/18 passed in WPC so and so. You are also requested to bring all records available in the office along with the concerned dealing assistant with the office file, etc., etc. Then Milord will kindly come to the next page. Kindly see, as per the order of the Deputy Director of Elementary Education, Assam, wide dated 1918, an inquiry was conducted on the matter of selection of grade 4 Chowkidar of schools of Kachar district in pursuant to advertisement made during the year 2005-06 under Kachar district in connection with WPC number so and so and link case so and so, so and so, so and so. The Honorable High Court had passed orders in the above mentioned 4 number of writ petitions and directed authority to prepare a merit list afresh with cooperation from the district elementary education officer. Accordingly, notice was served to the DEO Kasar to submit documents in respect of the petitioners, candidate for the post grade 4 of the school of LP and ME schools of Kasar district. The Honorable High Court has also directed to complete the exercise within a period of 4 months. Anil Fukan, superintendent, was engaged as the presenting officer in the inquiry. Accordingly, a hearing was conducted on 30/10/2018 in the office chamber of Sri Manoranjan Kakoti, Deputy Director, Elementary Education, with the following 55 number of headmaster of upper primary schools, and they have submitted their written statement regarding the position of the candidates and marks obtained in the interview. So, my lord, this is how all these 55 headmasters participated. Then please come to page 74. Kindly come to that finding portion. After verification of documents and reports as mentioned above, it is found that number of candidates may be selected for posting in the post of grade 4 post of Kasar district as follows. So, my lord, out of this entire bunch, 50 were found to be genuine, my lord, at page 75. Then, my lord, will kindly come to the conclusion portion towards the bottom of page 75. From the above finding, the inquiry committee has come to the conclusion that 50 candidates for the post of grade 4, where there is no conflict, may perhaps be selected for appointment. So, a committee constituted by the director, headed by my lord, the deputy director and superintendent, they had gone into the entire aspect of the matter and they came up with a list of 50. Now, pursuant to that, that list was forwarded to the authority for necessary action. Now, my lord, since nothing was forthcoming, we filed another writ petition which starts at page 80. If your lordship would kindly come to page 89. Para 4. It is the case of the petitioners that the names of the petitioners finds place amongst the 50 candidates so selected and published by the order of the Deputy Director, Assam, on 7th of March 2019. However, in spite of such an order issued by the Director, publishing the select list, authorities have not taken any decision to appoint. In the result, consequential action of appointment to the post of grade 4 for which petitioners had been recommended has not fructified till date. Accordingly, petitioners have sought for necessary direction to be issued to the state respondents to approve the same and issue appropriate orders. This court, after having perused order dated 9/3/19, is of the view that concerned authorities had verified the matter regarding selection of the candidate for appointment to the post of grade 4 in various schools in Kachar district, and accordingly said order was issued by publishing select list consisting of 50 candidates in respect of Kachar district. Under such circumstances, there should not be any difficulty on the part of the state authorities to act upon the same and issue necessary appointment orders. Accordingly, respondent authorities, more particularly respondent number 1, is directed to consider the said select list published by the director, and if the same is approved, the necessary appointment orders may be issued by the appointing authority, that is director of so and so. Well, Lord, pursuant to this, that impugn order has been passed by the government, my lord, that your lordships will find at page number 101. And kindly see, now they are reiterating their old story. Please come to me, Lord, the second subpara. Finance SIU has informed that any appointment that has to be made by the government has to be in accordance with the service rule as existed at the time of the initial appointment process. As per your report dated so and so, it has emerged that there was already an existing guideline issued on 16/12/05 and selection committee of the directorate had rejected 3 numbers of different select lists submitted by DEO CASA due to violation of the said guidelines. My lord, those rejection has been attended to. Those have been rectified. Now they are resorting to the old, my lord, story. In the light of the effects exit guideline layer framework is not in a position to accord approval. But this is sheer arbitrariness, my lord. This aspect that there were 3 lists, this aspect was taken note of by this honorable court, where an inquiry was directed, director instituted a committee, the committee found. Now, my lord, SIU approval is required for what? That whether there are 48 posts for Kachar district or not, which is reflected in that letter at page 33. Now, finance approval can be post facto also, my lord, since in the meantime, a requirement is there, I'm not disputing that. But that can be post facto. Only thing is regarding that 48 number of posts. On that plea, how can our appointments be put on hold? Well, Lord, this is arbitrariness, my lord. If your lordship should kindly come to page number 34 for a moment. All that finance has to certify is at page 35, my lord. Page 35. Statement showing district-wise number, grade 4 post advertised. Now, Kachar 48, rest are all done. So at that point of time, there was no SIU approval. Now, all that, because in the meantime, my lord, this requirement has been envisaged. Very well. It can be post facto also. My selection cannot become bad for that. It's a procedural formality. You comply with it. Approval does not mean, my lord, unless the express. So there is a judgment of the Supreme Court, but the Supreme Court says, my lord, if the expression only approval is used, it could be post facto also. It is only in case of where there is a requirement or no prior approval is required, then things would be otherwise. Now this fine SIU approval you can give now also. But for that, my selection cannot go down the drain. So let my learned friend obtain the instruction regarding SIU approval. That's all post facto, my lord. Possible specify in the order.
Not post facto, my lord. Lordship will see, my lord, the document just now I have placed, my lord. It is 4th of July 2005. May I read it, my lord? On expiry of the term of the state level empowered committee, there is a SLEC. On 36/2005 and pursuant to enactment of the Assam Fiscal Responsibility and Budget Management Act, that is AFRBM Act of 2005, the Governor of Assam is pleased to dissolve the state level empowered committee, which was constituted by OM dated 6th of December 1999. From now onwards, the Finance Staff Inspection Unit Department will look into the rationalization of requirement of staff in various state government offices. The SIU will undertake the following tasks. Roman 2, Lordship will see. Before filling up any vacant post, the concerned administrative department will obtain prior approval of the finance SIU department, who will examine the justification for concurrence of that post and recommend for filling up of the post or its abolition as the case may be. Now, this has been issued on 4th of July 2005. The entire selection process was instituted pursuant to the letter of December 2005. So prior to that, SIU came into being. It was there. Prior approval is necessary.
And no, fine, that's fine. But then according to the senior counsel, the other districts, they've all been filled up. Obviously, the all these other districts, so did they have the SIU or not?
So that, my lord, part, of course, my lord, the education will clarify. But one thing, my lord, so
except Kachar.
One more thing, my lord, page 35, lordship will see the number of posts was 48 initially. Now in the inquiry report, they say it's 50. So how, my lord, is 50
That can be,
against
that
48?
can be taken care of.
No, no, it's not about.
No,
taking
no, my
care
lord will
of-
kindly come to
These
page
are details of
115
record.
for a moment.
Lordship,
115.
grant me on some time to file my affidavit. We'll give it and Lordship, thereafter Lordship will consider.
Kindly see, my lord, they say it can be given 8th of January 21 regarding approval for filling a 4 sanctioned vacant post of grade 4 Chowkidar in Hailakandi. Now, this was given in 2021. Is it not post facto approval? And my lord, my learned friend will also obtain the instruction whether in respect of the other posts contained in that letter, there was SIU approval was there or not.
Yes,
If it was not there, if it was not there, how come they have given the post facto approval? And why not to us?
My lord, that may be indicated.
Heard Mr. K. N. Chaldi,
Oh, yeah.
senior counsel, assisted by Mr. B. Progressed, learned counsel for the petition. Mr. B. Gogar, learned standing counsel, finance department, shall take instructions. Oblique file affidavits. As to whether post facto approval for the 48 post of grade 4 employees pertaining to Kachar district can be given by the finance department. Post facto SIU.
SIU approved.
Yes, SIU approved. Learned standing counsel finance department shall also take further instructions whether there was SIU approval with regard to the other districts. Other districts,
Mentioned in page 35.
Other districts mentioned in the
Annexure
what is this? Annexure 1B?
1B, my lord, 1B.
Annexure 1B, which is appended with the communication dated 16 December 2005, written by the Director Elementary Education Assam and addressed to the district elementary education officers within bracket or let such instructions be.
Whether these particular posts, other posts have been filled up or not.
It has been filled up.
No,
All right.
Okay,
Yes.
whether
all instruction
SIU
is to
whether SIU approval was there for the other districts and whether
they will
Those posts were filled up.
whether those posts have
Yes.
already been filled up.
Yes, ma'am.
Okay. When do you want?
After 2 weeks.
After 2 weeks.
Also, can you give a date after 2 weeks? Give a date after 2 weeks. Any date convenient or not?
17th?
My lord,
No, hearing day or no?
on 19, you want a hearing day? 19.
19th.
Also there. Deeply.
Five.
Okay. With reference to the subject cited above, I have the honor to send here with the proposal received from the district elementary education officer, Kamru Rural, regarding regularization of service of Sri Madhucharan Sarkar, working Chowkidar of Disciplinary ME School, headed by Sri Sushil Kumar Sarkar, against the sanctioned post. In this connection, it may be stated that as per the government order memo number so dated 29th March 2014, the working teaching staff of Missionary ME School headed by Sushil Kumar Sarkar are getting monthly salary except the grade 4 employees of Mr. Madhucharan Sarkar, that is the petitioner here. The Nisime MA School was provincialized during the year 1991-92. After provincialization of the school, one post of Chowkidar was allotted to the school for regularization of the service of the incumbent working as Chowkidar with effect from 27 to 1996 by this office order number so and so dated 13 March 1996. But the then district elementary education officer Kamru had not been regularized in the service of Madhucharan Sarkar as a matter of provincialization order of Missionary ME School was connected with the High Court cases. Post was originally created by
After this.
After the Ashir, thereafter several representation was made before the authority concerned. But now annexure 20, kindly turn up at page 102. Here there have rejected my petitioner's case on the ground that he has not approached the authority concerned at the relevant time. I'll just read out. Relevant portion is at page 103. I'll read out. In inviting a reference to the above, I am directed to state that regularization of service of C. Devachan Das, assistant teacher, and C. Madhusudan Sarkar as grade 4 Chokidar in the disciplinary ME school at this stage may not arise as their services were not regularized at the time of provincialization of the school and they did not approach the competent court challenging the non-regularization of their services. It is also appeared that their initial appointments were made following the due procedure, hence their appointments were not irregular but illegal. And hence void ab initio. In this regard, the verdict of the Honorable Supreme Court held in the case of Secretary State of Karnataka versus Umadevi and others. Now, thereafter, Lordship, we have challenged this order before the Honorable Honorable High Court. That is at page 107, and the relevant portion is at page 109. Page 109, Lordship. Para 5. The court, this honorable court set aside this communication order. I'll just read. From the state point of view, we interfere with the communication dated 10/6/2019 and remand the matter to the authorities to the government of Assam in the elementary education department to give a fresh consideration to the claim of the petitioners for regularization and salary as has been paid to the other employees of Nizamari ME School headed by Sri Susil Kumar Sarkar as per the order dated 29/3/2014 and pass a reason order thereon. If in spite of such consideration, the petitioner are still not entitled to the provision and to receive their salary, appropriate reason order to be passed. But the same reason they had not approached the earlier when the case of the drop teacher were considered should not be reiterated once again. The requirement of passing the written order to be done by the Commissioner Secretary of Government of Assam in the Elementary Education Department within a period of 2 months from the date of receipt of the same. Thereafter, Lordship, can you turn up at page number 26, page 123, annexure 26. The Education Department, Lordship, passed a reason order that is 124. Page relevant portion is at 124. Paragraph 1. Paragraph 1, Lordship. The services of Sri Dabacharan Das, assistant teacher, Sri Madhusudan Sarkar, grade 4, are to be regularized. They admitted my case that they are to be regularized against a vacant post indicated by Director Elementary Education Assistant by this program concern. After due approval, concurrence of Finance Department. So till that time, after passing of this order, no order has been passed. It is still now with the lying with the Finance Department. They are not doing anything. That is my case, Lordship.
Yes,
Hello, I'm appealing for Education Department.
Charlie.
From where my learned friend is making the statement that it's lying in the finance department, I would like to see Lordship.
Lordship, I have made an RTA regarding this.
No, after this order was passed,
Mm.
the 26th July 2021 by the Special Commissioner.
Yes, sir.
Now, whether you have put up the file to the Finance Department, have you put up?
Lordship, I have made a RTA, Lordship. So they have replied that with reference to this. I'll just. Last page, Lordship. Last page with reference to the
1 minute. Let me at least get the book.
last page, Lordship. With reference to the subject cited above, I am directed to furnish here is a copy of the letter under reference informing that the concerned file in this regard is not with the department and is presently with senior standing counsel of the department. Lordship.
So that is not Finance Department.
No, Lordship, prior to that, Lordship is there. Prior to another letter is that with reference to the subject cited, I'm directed to request you kindly to return the physical file number. Matlab from Deputy Secretary wrote to the Deputy Secretary Government of Assam Finance Department. Lordship, with reference to the subject cited above, I'm directed to request you kindly to return the physical file number so and so, which is needed in order to furnish the information sought by the RTA petitioner, Sri Dilip Kumar Rao, gentlemen.
Who is this Dilip Kumar Roy?
He is an ex-president of the All Assam ME Teachers Association.
Someone from the.
He made a RTA because the petitioner said they approach him for that.
Yes.
Lordship, here, since we cannot say for sure where the Lordship may grant us some time, here the education department can also find out. Because since it's the education matter, Lordship, here the file will be pending with the finance department. It does not transpire from the communication, Lordship. Let us get instructions regarding that. And in the meantime, we'll also get the status of at what stage of the matter is in the department, Lordship, because from the communication, we cannot make out, Lordship.
Okay, heard MS.
Jaipur.
J. Bull, Learner Council for the petition. MS STTL and the Standing Council, Elementary Education Department. And Mr. H. Alia, Learner Standing Council Finance Department. Shall take instructions with regard to the status of the case of the petitioner. After the order dated, this is what date 20th July 2021 was passed by the Special Commissioner, Elementary Education Department, within bracket, annex year 26 to the petition. Okay.
Lordship.
How, when?
2 weeks time, Lordship, in 2 weeks time.
List after 2 weeks.
Lordship, date may be fixed, otherwise it not come up. Date may be fixed.
This is which matter, 2024 matter, it will come up.
15.
May I please, Lordship? Lordship, kindly peruse the last order of this honorable court. One I read now. Not accordingly.
Yes, what happened?
Accordingly, hearing was taken place. And in the hearing, Lordship, the inspector of school directed the petitioner as well as the respondent number 5, that is the in-charge principal of the school, to petitioner was directed to make cooperation with the principal, and principal was directed to, Lordship, take all steps and to make the audit of that said period, and also directed to, Lordship, procure the, Lordship, NOC.
Yes, where's the report?
Report is awaited, my lord. My instruction, my lord, telephonic instruction. They are seeking some time to produce the report.
Was the hearing, did the hearing take place on
Yes, my lord.
19th?
Yes, my lord.
Hearing taken place.
Yes.
Now, Lordship,
Hearing
the
was
headmaster.
conducted. My lord may give 1 week time, my lord. I will produce the report. My lord.
I am not objecting at that time, Lordship. What is happened, Lordship? After hearing, Lordship, the inspector directed me to make cooperation with the headman, with the principal. And principal was directed to take all possible steps and to issue the NOC. My lord, I again and again, Lordship, approaching the in-charge headmaster, principal of the school, Lordship. He is not taking any step till date. Finally, Lordship, on Friday, Lordship, I wrote a letter to the inspector of school regarding the situation, lordship, that has not been, lordship, taken any step by the principal of the school. He's neither appearing before this honorable court even after getting this notice, nor taking any step.
That we will make him appear. Let us first see the report. After
Ma'am.
that, we'll pass orders.
He may serve a copy of this letter, my lord, so that I can share with the inspector.
But Mr. M. Khandan accounts for the petition. Mr. N. G. Khatania. Learned Standing Council, Secretary Education Department submits that pursuant to the order dated 2/8/2024 passed by this court, comma. The Inspector of Schools, comma, KDC Karimganj, conducted the hearing on 19th of August 2024. However, comma, these, he therefore prays for a week's time to enable him to place the report before this court. Stop. The prayers allowed. Please the matter even on.
Can it be 12, lordship?
Okay.
12/9.
12 September.
Obliged.
Oblast.
16.
Wait, please, Your Lordship. This is the second round of litigation, Your Lordship. In the earlier round of.
Yes, where's your affidavit?
Some time to file our affidavit, madam.
What happened? Last time you were given to. You received, you have received your instruction.
I have received the instruction.
Last time also, Your Lordship, they
Yeah,
received the instructions.
okay, heard Mr.
MH.
MS Laskar and Council. for the- MSS to tell the standing council element to education. Department. It is allowed 2 weeks time to file contract. Stop. List after 2 weeks.
Lordship, you kindly give a date.
It will come 2024 matter.
Lordship.
It will come.
2021.
May Lord, may it please the lordship.
Hmm.
My lord, item number 21 may be taken, my lord. In that, my lord had passed an order on last occasion.
Item
21. There's a stay vacating application, my lord, in it.
Item 21, I am for the petitioner, my lord. Lordship was inclined to dispose of the measure, my lord.
what is it?
My lord, it is, my stay vacating application is there, my lord. My lord, may,
Item 20, if your lordship is taking up item 21, I am for the petitioner, my lord.
my lord,
No, what is item 20?
my lord, item
20, my
20.
lord, against the same order, my lord, he has prepared a repetition, my lord, challenging the impugned order, and the governing body is also challenging the same order. His challenge is that, my lord, he has been punished by deducting 2 increments. That is his challenge. And our challenge is that, my lord, despite there is finding of financial irregularities against the, my lord, respondent herein, the petitioner in other petition, my lord, she has been, my lord, reinstated as principal, in-charge principal of the college. In-charge principal, not regular principal. Now, process for regular principal has been initiated. My lord, advertisement has been published. Interview is going to be held on, my lord, 2nd of September. So, my lord, let the post be filled up by a regular incumbent.
That 1 minute.
By this court. By this court. Yesterday, join
biometric shot মানে সেই পুশ কৰে নাই ডাইৰেক্টৰ কম্পানী লাগিছে বুজিছে বায়োমেট্ৰিক shot নেকি নকৰে তাক
Last one and over.
মেট্ৰিক shot ক্লাছ কৰে
Actually, to নাই বুলি কিয় কোৱা?
Yes.
Yes, my lord, may I just submit here? Input it. My lord may see, my lord, the annexure 24, page 95. Of their repetition, 1941.
If your lordship is taking up the repetition, my lord, I'll go the first, because I'm the petitioner in the repetition, my lord.
1941, my lord.
Yes.
My lord,
No,
page 95.
What do you want in that? You are a petitioner in this writ petition.
No, my lord, I am the respondent, my lord. What has happened was here, they had filed a writ petition challenging the order dated 30th March 2024 at page 95. My lord, as per that order, I was reinstated as principal after disciplinary proceeding was initiated against me. And I have filed a writ petition challenging that order on the basis of on the account that the disciplinary proceeding was not proper. But my lord, what had happened, I had on the first date, an ad interim injunction was passed on 5/4/2024.
Whether lordship is taking up the IA for the vacation of the interim order or taking up the writ petition. If your lordship is taking up the writ petition, my lord, I will place the facts of the
No,
case.
that's exactly
My lord.
correct.
Yes.
So let him argue in the.
Yes, my lord, my lord.
Affidavit has come, isn't that?
Yes, my lord.
Affidavit has been filed, my lord. I have also filed reply.
I have also filed my IA, my lord. My lord, I have filed a stay vacating because despite there being an order of the disciplinary authority that me being reinstated in the principal, the order of their affidavit against my IA clearly states that the single judge, when they passed the order, the order had been misread because I have already been reinstated as principal as by the order. That is why I have filed the stay vacating. And that is why on the last occasion on 13th, if my lord may would recall, my lord had fixed this matter for urgent disposal. My lord, this order is very much clear. So let him start my lord first, then I will give my countermand.
My case is that, my lord, I am the governing body of the college. My case is that, my lord, the petitioner, she was the drawing and disbursement officer of the college since the provincialization of the college. The college was provincialized with effect from 1/1/2013. And her husband was the principal of the college. He husband of the my lord, respondent number 4 here in my lord.
Okay. Who's the respond number 4?
Kalpana Goswami, my lord.
Okay, you are the respond number 4.
Yes. Yeah. Husband of the respondent number 4 was the principal of the college. His service was not provincialized because of his my lord, disqualification. But he was working as the principal, holding the internal affairs of the college. The respondent number 4 was appointed as the DDO as there was no regular principal of the college. And the post of principal was not also sanctioned. After working as DDO, in connivance with her husband, who was working as principal, she has been involved in financial irregularities of the college, which was brought to the notice of the higher authority by the governing body and local authority. That is after her suspension, when the matters were placed before the higher authority, the authority, on finding privacy irregularities, she was placed on the suspension. The respondent number 4 was placed on the suspension. The inspector of schools was appointed as the DDO, drawing and disbursement officer. The inspector of schools, he conducted an inquiry after he was appointed as DDO. Thus, we'll find the inquiry report at page 55.
Page
55.
So let us first see the suspension order of the petitioner. I mean the private respondent.
My lord,
Page 74.
Hmm?
Page 74
Of this repetition.
of the repetition, 194.
Malik, there's a table.
Yes.
Page 74, my lord.
Yes. Inspector of School reported of meeting.
Now, let's will find the inquiry report by the Inspector of Schools at page 55. It starts from page 55, my lord. What kind of irregularities were committed by the respondent number 4 has been reflected in the report.
Yes.
My lord. So, my lord, after placing her under suspension, a disciplinary proceeding was initiated against her.
This inquiry report is
Dated, my lord,
7/8/2020.
Where can I find that?
my lord, page 55, my lord, 7/8/2020, my lord.
Yes.
Thereafter, my lord, page 81. A so-called notice was served upon the respondent number 4, my lord, by the Director of Deputy Director of Secondary Education, my lord, Higher Education, sorry.
8/2020. Okay.
Page 81, my lord. So-called notice, my lord. This is the so-called notice upon served upon the respondent number 4, my lord.
Yes.
Here, my lord, page 82, if you see page 82, background of the, my lord, so-called notice has been, my lord, narrated. Which led to the issuing the so-called notice, my lord. Conclusion. Hence, it may be concluded that Dr. Kalpana Goswami is culpable for being imposed with penalty for recovery of the amount which is still not accounted properly. In such case, she should not be reinstated unless and until the utilization certificate, audit report, SOE, and detailed financial statements of her spent expenditure in person, along with Sri Sandan Soikia, present in charge of the college, by be submitted to this office. Like this, thereafter, my lord, an inquiry was conducted by the authority. Inquiry report was filed at page, it starts from page 85. The report starts from page 86, but it was communicated to the respondent number 4 by page 85.
No, this is the inquiry report, isn't it? Or the show cause notice?
Yes, my lord.
The show cause notice.
Yes, my lord.
This is a show cause notice.
My lord, at page 81 is a so-called notice, my lord. Page 81 is the so-called notice.
Mhm.
And
Then this next page,
inquiry report is page 86, my lord.
then what is this page 82?
Page 82, my lord, why she was so caused, it had, my lord, the reason they have stated in page 82,
This is a preliminary inquiry.
my lord.
Then page 86.
Page 86, my lord, the inquiry report. May I read the inquiry report, my lord?
Yes.
My lord, page 80, I'll read the relevant portion from my lord, page 87. From documents submitted, Lordship has got it, my lord. 2, 3, 8, paragraph 8, my lord. From documents submitted by Dr. Kalpana Goswami and her written statement and other relevant documents and evidence produced before this committee, it is clear that the construction of science building has not been done as per the plan and estimate of the construction project. She has admitted in her reply that the science building has been dismantled subsequently to locate the RUSA building, and the laboratory equipment and computer, etc., are kept in the college premises as well as partly in the women's hostel. She has failed to submit the measurement book as asked in point 4 of the so-called notice to her. She justifies such non-submission to the date of Assistant Engineer PWD, which is not acceptable or justifiable. She has failed to recover fully the remuneration paid to teaching and non-teaching staff as required of her in point 7 in so-called notice to her. She has also admitted that only 4 staff members has refunded the money. She has further shown that she has purchased book worth of 77,32,000 in various installments, which require further verification as there is an iota of doubt in the first installment allocation of 50 lakhs for general development assistance for DHC. Further, it is also found that she diverted the construction fund in respect of science building. This amount to an unfair practice. She has purchased other items from the fund desired for science building. As such, even after giving ample opportunities, Dr. Kalpana Goswami could not justify her position in respect of proper utilization of funds allotted to her so far. Considering her present position, the authority may take appropriate steps under Rule 7 of so and so. In the meantime, my lord, during this process was going on, the higher education authority, my lord, directed the governing body, my lord, informed the governing body of the colleges. But as the post of principal was not created at the time of provincialization of the college, it was created by page 89. Page 89. There is an order dated 9/2/2024.
Yes.
Thereafter, a communication has been issued on 2/3/2024 at page 91 by the Superintendent of Police to the governing body of the college, my lord. May I read, my lord? Page 91, my lord. In inviting reference to the above, I am directed to inform you that a regular inquiry by under reference has been initiated against Kalpana Goswami, principal in charge under suspension, Feraskat College, Deotola, at the instance of government letter number so and so. In this regard, you are requested to furnish the details as follows. These details were called from the governing body of the college. Thereafter, the president of the governing body right letter at page 94, submitted all the required documents. A criminal investigation is also going on against the respondent number 4. All of a sudden, the impugned order at page 95 has been issued by the Director of Higher Education, reinstating the respondent number 4 as in-charge principal of the college. She is an associate professor of the college. She is an associate professor of the college. She is not holding the post of principal on substantive basis, my lord. She has no right to claim the post of principal as a matter of right. She was appointed as a in-charge principal. She was found to be involved in financial irregularities of the college. A criminal proceeding is going on against her. Investigation is going on. And at this stage, the Director of Higher Education, by this impugned order at page 95, has reinstated the respondent number 4 as in-charge principal of the college, which will, if on her reinstatement as in-charge principal of the college, the entire educational environment of the college will be disrupted, my lord. This is the reason, my lord, for which the impugned order has been challenged by the governing body. Governing body wants a clean person to head the college. Principal is the head of the institution. And in the meantime, my lord, on sanctioning the post by the government, a regular selection process has been initiated to fill up the post. Advertisement has been issued. Applicants many intending candidates has filed submitted their applications. It has been scrutinized. Date of interview has been fixed on 2nd of September. At this stage, if the respondent number 4 is reinstated as principal of the in-charge principal of the college, the entire process will be disturbed.
What does this order say?
This order, paragraph 6, my lord. I'll read from paragraph, entire order I'll read, my lord.
Not required, just as.
Now, whereas she has been found guilty of financial misappropriation, she's got it, my lord. Whereas she has been found guilty of financial misappropriation as per inquiry report submitted on 15/3/2024. Whereas she has been given enough opportunity to offer her written and oral representation against the allegations and inquiry report. Therefore, in exercise of power conferred on the undersigned by the Assam Service Discipline and Appeal Rules 1964, 7(2), withholding of increments of promotion, I hereby impose upon Dr. Kalpana Goswami, the charge officer, the penalty of withholding 2 increments with cumulative effect. She has been imposed with punishment. That part has been challenged by my friend in the other petition. Further, she is hereby reinstated with immediate effect. If she is reinstated with immediate effect, then she will be reinstated as associate professor. Her substantive post is associate professor in mathematics department. Next line, my lord. Whereas regarding recovery of the excess remuneration paid to the teaching and non-teaching staff of the college after reinstatement of as in-charge principal, she would take necessary steps to initiate recovery and accordingly submit a report to the office on the action taken by her.
That's where you are wrong, Mr. Saikia.
Against this part, we are agreed.
Here, this is reinstated with immediate effect. In the next paragraph,
Yes.
it is clearly shown that after her reinstatement as principal in charge.
Yes, that against that part we are agreed, my lord. Against that part, because my lord, she has already been found to be involved in financial misappropriation of the college, and she has been reinstated as in-charge principal of the college. Again, she has been given the same nature of duties by the impugned order. When there are eligible persons at the college, they could have been appointed as in-charge principal. In the meantime, another person has been appointed as in-charge principal of the college. That order has also not been recalled, appointing that other person, my lord.
He is working as in-charge principal without any irregularities. And the regular process has been initiated. A regular principal is going to be appointed very soon. And at this stage, she may not be registered as in-charge principal of the college. That is our prayer before your lordship. As governing body wants a clean person to head the college, head the institution.
A departmental proceeding was initiated.
Yes, my lord.
Against the respondent.
Yes, my lord.
And after they came to the conclusion that the inquiry report, on the basis of the inquiry report,
My lord.
Withholding of 2 increments with
Yes.
cumulative effect was imposed on the private
Yes, yes.
respondent. Correct.
Yes, my lord.
And after she was
Reinstated.
with immediate effect
With
as
immediate
principal in charge.
Yes, ma'am. Against reinstatement, we have no grievance. She can be reinstated in her substantive post. Otherwise also, my lord, she will be reinstated as associate professor only. She will not be reinstated as principal. She is not holding the post of principal on substantive basis. The post has been created very soon, very recently, my lord. Very recently it has been created and it has been advertised after creation. Regular process has been initiated for filling of the post. She has been reinstated as associate professor. We have no grievance against that, my lord. Let her work as associate professor, but she should not be given the financial liabilities so that she will be able to again misappropriate the college fund.
What is the affidavit saying?
The higher education, my lord, they have not filed any affidavit in this case, my lord. Only that is the only difficulty, my lord. The department has not filed any affidavit. My friend has filed affidavit. We have also countered that.
You have not filed your affidavit. You have any instructions?
That is the only difficulty, my lord.
See, the reinstatement orders show that the petitioner is, the respondent is reinstated as principal in charge.
Yes, ma'am.
Correct.
My lord,
Yes, yes.
my lord, may I just come in? My lord, this is the speaking order after the disciplinary proceeding has been over. My lord, here under 226, the governing body, first of all, they don't have any right. If they have any right, they could have challenging the order. Because, my lord, this order has been passed by the DHC, the Director of Higher Education. And after, my lord, may read the first paragraph. Whereas a preliminary inquiry was conducted against, at para 95, page 95, was conducted against Dr. Kalpana Goswami, principal in charge, dated so and so, whereas department proceeding was conducted against Dr. Kalpana Goswami, principal in charge, filed order dated, whereas an inquiry report on Dr. Kalpana Goswami of Khajra by the inquiry officer, presenting officer, copy of which was duly provided to the charge officer, dated, mentions that after taking everything into consideration, my lord, they have said that at the bottom, therefore, in exercise of the power conferred on the undersigned.
That I've seen.
Yes, at the bottom, my lord, also. Moreover, college authorities will take steps for appointment of permanent principal in the Khajarat College of after the model code of conduct, which is in force of the general election 2004 is lifted. So this submission what my learned friend is submitting, that the process has been started. That also has been taken into account while passing this order. So now, if he has any, how can he have a grievance and file a writ petition? What does the authority of a governing body has against a disciplining authority, my lord? Well, how, and he is coming under this High Court as an appellate authority and asking these orders to be reviewed. Well, this is nowhere in the law it can be substantiate that once a punishment has been imposed upon me, the cumulative punishment has been imposed upon me, and they have given me a direction on what 226, how can it be challenged, my lord, first of all? And second of all, my lord, I have challenged this order. But my challenge into order is because of that, the proceedings and the gravity of punishment that has been imposed upon me. And that is why I have filed 2884, which is linked today. But my lord, once the reinstatement has been done to me as principal in charge, my lord, the order of this court was wrong, that there was no finding in such effect. And that is why I have filed this stay vacating. My lord, may just take up my IA 1811. If the stay would have been granted for some other reason, I could have understood. but the stay has been given on the effect that that was not reflected in the order as reinstatement. Page 3, my lord. Page 12, my lord.
Yes.
Of my IA. The respondent number 4 at the time when the department proceeding was initiated against her and prior thereto, where was she placed under suspension, was functioning as the principal in charge of college in question. According to the DHE, while passing the order dated 30/3/2024, after imposing of the said penalty, proceeded to reinstate in her service with immediate effect. The said reinstatement being without the further specification as to whether she would be reinstated as principal in charge or against a substantive post of associate professor, claim may arise from the respondent number 4 requiring the college authority to reinstate her as the principal in charge of the college. Accordingly, the proceeding has been initiated by the college authority. The line here, the said reinstatement being without the further specification. And on this account, only the Honorable Court had passed the order. The said reinstatement being without the further specification as to whether she would be reinstated as principal in charge or against a substantial post of assistant. A claim may arise from the respondent number 4 requiring the college authority to reinstate as a principal in college. According the present have been instituted by the college authorities. It was on this claim that I would be asking for the principal. They had filed this writ petition. That is what their submission, and that is why this order was part ad interim. And now my reply to that, which they have filed, my lord. The affidavit in opposition which they have filed at page 97.
97?
Yes, my lord. There are 5, my lord. That as regard to the averments made in paragraph 2 of the IA, the deponent begs to state that the basic challenge of the writ petition was that the appellant respondent number 4 was reinstated as principal in charge of the college despite her proved misconduct as she was involved in misappropriating the college fund while functioning as in charge principal. This aspect was considered by the Honorable Court while passing the order dated 5/4/2024. However, some inadvertent typographical error were crept in the said order while recording the facts of the case. The inadvertent error cannot give a right to respondent number 4 to vacate the interim order. He himself has admitted that there was an inadvertent typographical error, and himself has said that I cannot have any claim over the principal in charge. I am asking my claim to the post of principal in charge on the order dated of 30/3/2024, where the DHC themselves, after imposing my punishment, has given me that post. So how does a governing body of the college, if affected by it, how can they take off the position out of me, my lord? That is my only case. And my lord, I want this, my lord, I plead before my lord that this IA should be disposed of, my lord, because I am hanging here. Because being the senior most, being an order of punishment imposed upon me, my lord, and being reinstated as principal in charge, I'm still not able to function from April onwards as principal in charge. And there was a particular condition as to why I was reinstated as principal in charge. And that order is very much clear. It says that whereas regarding the recovery of excess remuneration paid to the teaching and non-teaching staff of the college, the extra remuneration that was paid after reinstatement as principal in charge, that means I would, take necessary step to initiate recovery and accordingly submit a report to this office on the action taken by her. So this was the appropriate reason as to why I was reinstated as principal, that if the fund which was paid in excess, to look after it, to give a report after it. Now, because of this order, which was inadvertently passed by submission of wrong facts, I have put in a challenge of stay vacating because I have to be reinstated. And that is why DHE, while passing this order, had carefully examined that if I am liable, if I'm guilty of this, of misappropriation from whatever, I'm not admitting to it, but whatever the finding is, I have to be reinstated as principal and have to do it. And now that thing has been put into pause. Now, my lord, one more thing. My lord, just as per how the inquiry was conducted, even though if it's not a matter, my lord may see the show cause notice.
Which petition?
That same repetition, my lord. Page 81.
Page
81.
yes.
My lord, may see, show cause notice under the rule 9 should have charge. Against which charges? There are no charges leveled against me. No charges, nothing is leveled against me. There is no charge framed. How can this qualify as a show cause notice, my lord? And now they are saying the report of inquiry. If this is the preliminary, this is a fact-finding inquiry, my lord. If the fact-finding inquiry is there, I have to have a level of charges against me. There is no level of charges against me. And then what my learned friend was submitting was at page 55. That was the inspection report. That was not an inquiry report. Page 55, my lord. First, with reference to subject cited above, please find herewith the detailed inspection report of Kejarat College, Deltola, Lakhimpur for the period so and so enclosed herewith. It's an inspection report.
Yes, on this issue, see, in this inquiry report, at page 86, no, not this,
82 Lord.
page
82 Lord.
82. Yes. No, no, not this. Inquiry report.
It is 86 dash.
86, my lord. Page 86, my lord.
Yeah, come to page 87. The bottom part. Para 3.
Yes,
Okay, we'll take up it to.
My lord.
The SP Shah, Learned Counsel for the edition in the PVC 284 of 2024. And Mr. IS Sankar, Learned Counsel for petitioner in the PVC 1941 of 2024. Mr. Dio Commander, Learned Standing Counsel, Higher Education, shall receive inspection. This matter again on 29th.
My lord.
29th.
Okay.
Thursday. Can it be on 31st, Lordship, Saturday? I'll get 2 days more time.
Okay, extend you.
Lordship, 31st. Okay, Thursday.
On Thursday, I have, Saturday, I have some problem, my lord. Let it be on Thursday, my lord. It's a work.
If I don't come up with instruction, Lordship, again I'll have.
Saturday, what is your problem?
My lord, there is a division bench matter that's pending. Well, again, that will be a difficulty. Because this Saturday is a working day and the matter was fixed on 24.
Then how about Friday?
Friday.
Make it Friday.
Alright.
30 supplementary list, admission.
That the production is. It's not yet come.
Made with this matter. In this matter, respondents are yet to file the affidavit.
Lordship, may kindly grant us 2 more weeks, Lordship.
You are putting for?
BTC, Lordship, on behalf of Mr. P9.
Heard, Mr.
P. Thakuria.
P. Thakuria, Learned Counsel for the petitioner. On request made on behalf of Mr. P. Nayak, Learned Standing Counsel. How much time? 2 weeks?
2 weeks, Lordship.
2 weeks further time is allowed to file conference.
Next.
This is 2 weeks.
32 of supplementary list, motion.
Yes, Manda, what is your case?
My lord, this is regarding my lord the admission in the B.Ed course.
the minimum qualification as per their notification, my lord. That was they set up that the 50 and 45 for scheduled caste and scheduled tribe reserve category. But while the result of the merit list was published, then my lord, they subsequently they by my lord, the annexer at page 48, annexer 3.
It was increased.
That was my lord, the cutoff mark was my lord, earmarked as 90 and 80. For unreserved, it is 90, and for reserve category, my lord, 80. In comparison to last year, that was my lord 50 and 60. So my lord, humble prayer is this, my lord, that as the my lord, admission is totally based on the merit. This is criteria is based on the merit. So when I my lord, somebody may get the 80, he may not be my lord, get the admission if somebody is coming above him. So my lord, my prayer, my lord, this fixing the cutoff mark is very much, my lord, exaggerated, and it is no having any rationality and not based on any my lord, conclusive my lord, reason. So my lord, my prayers, my lord, that should be my lord, reduced so that at least my lord, the qualified candidate as per the earlier previous year, my lord, the cutoff mark that is my lord, I annex my lord at page that is annex of 5 at page 56, my lord, where they have stated in last year this is 60 and 50. And 80 is my lord, too high for a my lord, reserve category candidate. My lord, ultimately what will happen, my lord, many candidates, though they are qualifying in this examination, they might may not my lord, prefer for the B.Ed. They
Where is
might,
that 80 and 90?
yes, 80 and 90 annex at 3, my lord, at page 48.
Oh. Yeah, Fukan.
So I pray, my lord, at least my lord, there should be some reluctance so that my lord, everybody can apply. If it is not getting any admission on the merit, he will go, my lord. But at least my lord, entry this restriction, that should be my lord. As per their own notification, they are saying that the qualification requirement is 50 and 45. This is BA and BSc. They can apply for the my lord. But no mention if this cutoff mark will be that and this my lord, that is not there. My prayer.
My lord, I take your lordship straight to page 49, my lord. On the last occasion, I have shown that clause, my lord. Page 49, NCT regulation, my lord. Down below, 3.3, admission procedure. Admission shall be made on merit on the basis of marks obtained in the qualifying examination and or in the entrance examination or any other selection process as per the policy. It is important, my lord. As per the policy of the state government or union territory administration and the university. So, my lord, on the last occasion, your lordship directed me to obtain instruction regarding that policy, my lord, policy matter. And my lord, this is the minutes, my lord, of the admission committee. Resolution number 1. Resolution number 1, my lord. May I read me? It's a minutes of the meeting held on 8 August 2024. Before the impugn notification. Impugn notification is of dated 12/8. It is 8/8. It is resolved that the cutoff points for admission to the B.Ed program for the upcoming academic session are 80 for the reserve category and 90 for the unreserved category. The cutoff was set in accordance with the requirement that more than twice, it is important, my lord, more than twice as many students apply as there are available seats across all colleges. 2 times, my lord. A student will receive 4 marks for answering a question correctly, as stated in the general information booklet. Therefore, the cutoff score of 80 means that if a student can correctly answer 20 out of 100 questions, they will be eligible to enter the B.Ed program. That means, my lord, 20%. Out of 400 marks, one will have to get 80. That is 20%. 20 question, 20%. Second, it is resolved that in case of OBC, MOBC category, Government of Assam notification number so and so will be applied where it is mentioned that OBC, MOBC category need to produce NCL certificate. 3. It is resolved that the college need to upload the merit and waiting list at least 2 days before the admission. There will not be a spot admission
the college need to submit the final admitted list of students on or before 28 August. So this is the policy decision of the admission committee, my lord. As per government notification, my lord, the cutoff marks for reserved category 80 and unreserved 90. And it is the academic domain, my lord. The Supreme Court is clear, my lord. If the policy decision goes against any statutory law, then this honorable court will interfere. Otherwise not. That Neha Anil Bobde case and Anushka Sharma case, my lord. There are so many cases, my lord. They are academic experts, my lord. Cutoff marks fixed, my lord. And I've got the information that there are altogether 3,000 seats. And this cutoff mark means more than 6,000 plus student will be covered under this 80 and 90. So last year, 50, 60, my lord, that is another thing, my lord. This year, out of 400 marks, only 80, that is 20%. It is the policy decision, my lord. And if it requires, my lord, then I'll file an affidavit to this effect.
You have this?
No. Well, regarding the policy,
This is
regarding his submitting it is a policy decision. Well, this is not a policy decision, my lord. This is not a policy decision of the university. This is a ballot policy decision. This is made by the admission committee. There is no mandate from the VC and other executive council. Then how that will be a policy decision, my lord? And moreover, my lord, in the last year, the students were performing better than my lord this year. And that time, my lord, their cutoff mark was 50 and 60. But this year, my lord, they are getting less mark, but their cutoff mark is most than almost twice of the last year. So, my lord, my prayer is that as per my learned friend, relying. Last day also I have showed my lordship. This is the my lord, the NCT guidelines, it is Annexure 4, where it is privilege given to the my lord, university to take their own policy decision. I am not regarding that sometimes as per the NCT, my lord, on the basis of the marks obtained in the degree and master degree, he is entitled to get the admission if somebody is secured 50 and 45. 45 is
no. This NCT regulation is very
yes,
clear.
yes, it is very clear.
3.3.
Yes, brother. I have shown in the last year or last occasion, my lord. The university has given, the government also given the liberty to take a policy. Policy decision means instead of going to the direct entry on the basis of the my lord, the marks obtained in the my lord, minimum qualification, that is in BA, BSc, they gone for my lord, the entrance test.
Okay.
That is okay, my lord.
Fukan, you file your affidavit by tomorrow?
My lord, not by
After
after a week, my lord, at least.
1 week.
Some time will be required, my lord.
Then, my lord,
By then what will happen to the
My
admission?
lord, since my lord, that
I may be allowed to
almost-
apply, my lord.
almost
I am not
complete,
final,
my
my lord.
lord.
No, not
Otherwise,
complete.
my lord, entire system will go astray, my lord.
No, my lord, 28 days last.
As per the read petition in paragraph 8, my lord, more than 10,000 students applied.
That is, I admit.
And the vacancy seats are 3,008. So as per this cutoff marks, my lord, more than 6,000 students will be covered for counseling. So, my lord,
See, Amanda, I see no reason to interfere with the decision of the admission committee. Because here they have said that if you can correctly answer 20 marks out of 100, automatically you'll get that 80.
Then my lord, lordship come to my lord. The first their notification for the entrance test, my lord. This my lord, page 22, my lord, 23.
Yes.
This is the general information, my lord. It is eligibility for as per the NCT norms. This is what, so where my lord, they have stated, this second para, my lord, is as per the candidate may be allowed to appear in the GUVET my lord 2024, provided he or she has passed the BA, BSc, BCom, or my lord, MA, MSc, ECom, my lord, this qualification is at least with at least 50% marks is for the general, and this is 45% for SC, ST. But nothing was mentioned that the student have to score minimum 20 marks and everything 20 question. Nothing was there. They said
that eligibility as per NCT
yes,
norms.
apply.
That is there.
Apply, my lord, for the entrance examination. But they have not stated that after the entrance examination, there will be another cutoff mark. On the basis of that, you will be selected. Nothing is there. I am not there, my lord. I am even at for sake of my
How
argument,
many, how many of you are before this court?
my lord, I'm 22 petitioner, 21 petitioner, my lord. My prayer, my lord, let us, my lord, apply. If, my lord, the lordship comes to against us, our application will be rejected. But for the time being, because the 20 is the last date, so, my lord, our application has already been, my lord, submitted before the concerned, my lord, institution. But because of that hurdle, that is been not uploaded. So that may be uploaded, and if it is not accepted, then our case will be gone, my lord. There no, I am not, my lord, hankering for any other relief, my lord, after this. My limited prayer, my lord, at least, my lord, that should be decided, and the policy decision, wherever my learned friend is saying it is not a policy decision of university. It is an admission committee, my lord.
That we'll see, after the
First,
first.
first one, eligibility stage, my lord.
Eligibility is that
The
is as per
second,
the.
counseling stage, my lord.
Yeah.
After the,
These are, we are go by the counseling. If it are,
Entrance.
my qualification is not covered, my marks is not covered, automatically in counseling, I will be rejected. But at
Okay,
least,
heard Mr. P. Manda, then the council. Mr.
PJ Fukun.
PG
for
for
one and
council throughout the university. You guys for weeks time.
Yeah.
To enable him to file up that. Very thorough. On top, you just say, after I heard P. Bandana, I also heard Mr. Ayala, the standing council, NCT. NCT.
three.
NCT. Then the standing council. NCT. Press a note. List after 1 week. Let them apply, we'll see.
we apply.
Lord,
It will be subject to the outcome.
Milord,
Yes, yes,
it is regarding Milord entry to the counseling process.
Ah,
Milord, it will be Milord entirely depend upon the outcome of this Milord writ petition. Milord.
exactly.
Milord. So Milord, at this stage, Milord, almost counseling is over, Milord.
No, my lord, counseling is not started. How
Today-
many is submitted, I don't know.
Today, 27,
20 is the
Milord.
last, 28 is the last date.
28 is the last date.
28 tomorrow, Milord.
Yes, I am ready to do
Milord,
while
kindly see the impugn notification, Milord.
In the interim, the respondents, particularly the respondent number
1 and 2, Milord.
1 and 2 are directed to permit the petitioners.
Milord, before Milord, that order, Milord, kindly see page 48, Milord, annexure 3, down below.
Yes.
6 and 7, Milord. Most important. Page 48 down below, 6. The college institution should upload the merit and waiting list in concerned college institution website at least 2 days before the admission date. 2 days before the admission date, Milord.
Yes, ma'am.
Same merit and waiting
My
list should be sent to the office of the academic register along with admitted list. There is no provision of spot admission. Now, para 7, Milord. The list of admitted candidates should be sent to the undersigned at so-and-so on or before 28 August, tomorrow. The admission list should be
too
sent in.
It no, my lord,
Milord,
that is already we
that
have submitted.
Counseling process would be over.
No, counseling will be started, my lord, face to face, not on the basis of
No,
that.
no, admission, it is for admission.
No, my lord, this is it is my lord, counseling phase will be, that will be my
List of admitted candidates.
list of my lord, admitted candidates should be sent to the undersigned on or before
So
28.
counseling is over.
No, my
Today,
lord,
I think it has to be uploaded 2 days before,
No,
before
that
28.
is my lord uploaded, but because of this my lord things, my lord, we cannot be finalized. But this is the things. We have submitted my lord.
One
This
other
is-
thing,
that-
I
that
should not
is-
point
that is
out,
with the
my lord.
pending, my lord.
The impugn notice was issued on 12th August.
And my lord,
Today is 27th, Milord.
our set of copies also there, my lord. We have submitted everything.
That you have submitted,
Yes,
Mahanda, but then, by now it's too late.
no, we have
I
submitted.
did not see this.
No, my lord, this
serial
is-
number 6.
That is submitted, my lord, but because of this hurdle, we cannot send the final candidate list, my lord. This is the things, my lord. This is submitted. If it is, my lord, comes to the
No,
consideration.
how can you say that they cannot submit the finals? It has to be uploaded 2 days before 28.
It is, my lord, uploaded,
That is
uploaded,
on
my lord.
26.
This is, my lord, uploaded, my lord. This is all the copies are
It is
there. my lord.
not reflected in the
This is
writ
uploaded.
petition, Milord.
All, my lord, 21 applications are there. This is uploaded, my lord.
Let him file affidavit, Milord. On this
Let
regard.
him file, my lord, the first affidavit, then I give the reply, my lord.
Verbal submission,
My
Milord.
lord, this is my submission. The documents are there, my lord. And sometime, my lord, it is extended also. Lordship can extend the period time also. It is that the lordship has the power. Because well, I have come much before, my lord. This is for the closing, before the closing date. That is
Then,
a,
Furkan, I think you should file your affidavit earlier than 1 week.
Milord, Milord,
I'll give you 2 days time.
Milord.
It's allowed 2 days time to file affidavit. Stop. List the matter on 30.
Mute.
Till then, you don't finalize the admission
Yes,
Milord.
till the next suitable date.
yes,
The respondents, particularly 1 and 2,
1 and 2.
are directed not to finalize the admission list of what is it? B8
B.Ed, my lord.
of B8 students for the session 2024-2025.
Mas-
22 of Delhi order.
Wait, please, Lordship, in this case, I have received the scanned copy of the record today, my lord.
My lord, may I please your lordship kindly peruse the last order written. 5/8/20.
My lord, may fix the matter in the next week, my lord, for final disposal, my lord. On the basis of the record, my lord.
You've got the
My lord,
copy?
scan copy I have received today, my lord. Hard copy, my lord, I will get it back tomorrow, my lord.
Okay. Then I'll record that.
My lord.
My lord, so many occasions they have taken time.
No, now at least something is happening.
My lord, kindly see, my lord,
Record to exact.
2 weeks time granted, my lord.
I've seen. I'm on
Different dates are already, my lord.
Mr. A. Gohan and the council notification. I'm as STTL and a standing council.
Elementary education.
Elementary or secondary?
Elementary, my lord.
Elementary Education Department submits that she has received the
Scan copy of the record.
of the records and therefore place for filing, place for 1 week time
Right.
to file affidavit. Place allowed. This is the matter on 5th of September. Mr.
Respondent.
Mr. D. Bhattacharya, and then standing counsel, accountant general, appears for the accountant general.
My lord, again, may I pray, my lord, as a last opportunity, my lord.
I'll remember that.
On different occasion, my lord, they have taken time.
Twenty-three.
Similar pattern. Thank you, madam.
Same order?
Same order.
25, hearing.
Yes.
May I please, my lord? In this case, my lord, the petitioner has been given premature retirement, going beyond the record of the service book of the petitioner, my lord. In this case, my lord, I have submitted list of deaths, my lord.
You have submitted earlier?
Yes, my lord. List of deaths.
Is the list of dates?
My lord, matter was actually hard for a time, my lord, earlier. And both the parties have submitted their written arguments.
You have submitted your written argument?
Yes, yes. ma'am. They have also submitted. it.
Huh? Yes.
My lord, in this case, on 19/5 to 1980, order was issued by the Registrar Guwahati University appointing the petitioner as a peon. That is at Annexure 1, page 20, my lord. Page 20 of the petition,
Yes.
Annexure 1. His name appears at serial number 25. Pavitra Kumar Nath. Thereafter, my lord, his service work was opened, my lord. The age of the petitioner was initially recorded as 8159 at page 24. Page 24.
81.
1959 in the left hand column upper side of 20 page number 24, my lord. It was cancelled, my lord. After cancelling that note, the subsequent note was new entry was recorded in the lower part, my lord. Showing his date of birth as 21/2/1963 as per SSLC admit guard, my lord. Last portion, my lord, of his note. It is handwritten, my lord. It is 21/2/1963. It was authenticated by the Deputy Registrar on 6/11/1984 in the middle part. Signature of the Deputy Registrar. So it was authenticated. Thereafter, my lord, service of the petitioner along with others were confirmed on 1/10/1987. That is at page 26. It starts from page 26, serial number 54 at page 28.
You are confirmed as on which date?
My lord, with effect from 1/10/87 at page 26, my lord, and except 4, it starts. They are different employees, my lord. They were confirmed in their respective post with effect from 1/10/87.
Yes.
His name appears at serial number 54, page 28. Page 20.
Yes.
Thereafter, petitioner was promoted to the post of typist on 21/12/92. Next up 5, page 30.
With effect from?
Sri Pavitra Kumar Peon and Development is appointed as typist on promotion in the pay scale of so and so. The benefit admissible rules and posted in the University Works Department, English. Is earlier typist promoted in place of other person, my lord. He was promoted on 21st December 1992, my lord. Thereafter, he was permanently absorbed against that post on 7/3/98. Next, annexure 6, my lord.
Annexure 6, page 31. As per VC's approval, let us show that the following temporary grade C employees are permanently absorbed. So in that list, along with others, his name appears at serial number 15, page 32.
This is with effect from?
No, effect has not been shown, my lord.
No,
Earlier he was promoted and
column 5.
'31, 12, 93.
93.
93. Thereafter, two numbers of advance increments were granted to the petitioner along with others. That is Annexure 7, page 33. His name appears at serial number 12. Thereafter, when Annexure 8, from typist, he was promoted to the post of LD assistant, along with others, my lord. That page, Annexure 8 starts from page 34, and his name appears at serial number 19, page 35. Thereafter, when Annexure 9,
1 minute. Yes.
thereafter, when Annexure 9, at page 37, service was confirmed in the their service was confirmed in the post of LD assistant. Several persons were there, and his name appears at serial number 42, page number 38.
This is what order?
My lord, order dated 27/9/11, my lord.
27 or 26?
Annexure 9. Two dates are there, my lord. 27 and 26 both are there.
Yeah.
Thereafter, my lord, there's a dispute, my lord. A notice was issued to the petitioner. That is the first so-called notice after 31st years of his service to explain regarding submission of misleading information as far as back on 1980 at the time of initial appointment. That is at page 39, Annexure 10. May I read, my lord? Submission of misleading information regarding your date of birth. With reference to the subject cited above, I am to inform you that while you applied for timescale through your application on 8/3/1980, you had mentioned your date of birth as 8/1/59 with an undertaking by you that the above statements are true to the best of my knowledge, and if found otherwise, I shall be liable to action. Copy of the application submitted by you for the timescale is enclosed herewith for your ready reference. Now, you have submitted an application on 7/12/15 with a supporting document regarding your date of birth where it is shown that your date of birth is 21/2/1963. That means that your earlier declaration regarding your date of birth in your application applied for time scale was not true, and accordingly you are liable for disciplinary action as per service conduct rules of the university for furnishing false information with your undertaking. Moreover, you have joined in this university on 2/4/1979 on daily wage basis. As per records, if your date of birth is 21/2/1963, as per document furnished by you, your age at the time of joining in this university was 16 years, 1 month, 11 days. As per the university rules, for initial appointment, the person must have to attain 18 years of age on the date of appointment. Accordingly, as you are working since 2/4/1979 in this university, your date of birth shown in the supporting document as 21/2/1963 submitted by you is objectionable and it needs a fresh inquiry. As such, you have violated the service conduct rules of this university by submitting misleading information regarding your date of birth, and you are liable to be penalized under the Rule 46 of Guwahati University Employees Service Conditions, Conduct and Appeal Rules 1970. Accordingly, you are required to be explained why disciplinary action under the Guwahati University Employees Service Condition, Conduct Appeal Rules 1970 should not be imposed against you for submission of misleading information to the university authority, and your reply should reach the undersigned through your controlling officer within 7 working days from the date of receipt of this letter. Otherwise, it will be presumed that you have nothing to say and disciplinary action are liable to be taken against you as per rules. So, my lord, this notice was issued after 35 years of service, my lord. Even after correct entry was corrected, earlier entry was cancelled.
When was that entry corrected?
1984, my lord. It is an extra. Annexure 2A, page 24.
Okay.
The earlier entry, that is 8/159, was to be cancelled, my lord. Entry was cancelled by the official concerned and subsequent entry was made by them.
Where's your admit card?
My lord, I have annexed one and admit card. That is annexure 3, page 25.
This is after
That
you,
is subsequent.
this is after you enter into service.
My lord.
You enter service in 1980.
Yes, my lord.
Okay.
During this long period, they have not put any question regarding that submission of false information by me. To that supposed notice, I have replied. That is an excerpt 11, page 42. Annexure 11, page 42, my lord. Kindly refer to your letter under reference to this on this subject. It is intimated that I was appointed in the time scale of so and so post, and at the relevant time I was not passed matriculation, and on the basis of the school certificate issued by the concerned headmaster, my date of birth was furnished in my application, which fact is undoubtedly true. One, fortunately, I was able to pass SSLC examination, and at the time, the school authorities have furnished my Date of birth has 21/2/1963, and accordingly, the authority has recorded my date of birth as such in the admit card, which is an authenticated and admissible documents in supersession of earlier one. Then the same was duly recorded and verified in the service book by the university authorities. So far information gathered. In this connection, it is intimated that there is no denial of the fact that I have not shown the attained the age of
I've
15
got
years.
it. I've got it.
Next, my lord.
So after that, you charge sheet it.
I know that is Annexure 12, page 44. This charge sheet is hereby issued against you under rule so and so, and you are required to submit your written statement for your defense why the penalties under Rule 46 of the Guwahati University Employees Rules 1970 should not be inflicted on you for the following charges based on the statement of allegation and office records mentioned below. Number one, you submitted false information and suppression of factual information regarding your date of birth. And that is 8/1/59 in your application dated 8/3/1980. When you applied for the time scale in the post of peon, and on the basis of your information furnished, your candidature was considered by the university and you were appointed in the said post. This is evident from the fact that as per the certificate of SSLC examination issued by the Board of Secondary Education in the year 1986, in your name, your date of birth is recorded as 21/2/1963. As per the service conduct rules, furnishing of any false information or suppression of any factual information in the application form would be a disqualification, and if it comes to notice at any time during the service of an employee, his service would be liable to be terminated. You are therefore charged for furnishing false information and suppression of actual information regarding your date of birth while applying for the post of peon in the university, and in which you were subsequently employed and unbecoming an employee of the Guwahati University. Number two, you joined in the university on 2/4/1979 on daily wage basis, and as per your actual date of birth, 21/2/1960. They have admitted in the charge itself, my lord. My actual date of birth is 21/2/1963, but they have not given effect to that, my lord. Your age was 16 years, 1 month, 11 days at the time of entry into the university service. As per the university rules, the person must have to attain 18 years of age on the date of his appointment. From this, it is evident that you have suppressed your actual date of birth and mentioned your date of birth as 8/1/59 at the time of your initial appointment to mislead the appointing authority to derive undue privilege. You are therefore charged with suppression of factual information regarding your date of birth to mislead the appointing authority of the university to derive undue privilege and unbecoming of an employee of the Guwahati University. You are to submit it, your written reply within 10 days from the date of receipt of this letter. In case you want to inspect any document, you may do so within 7 working days from the date of receipt of the letter with prior information to the undersigned, and your written reply should reach the undersigned in 7 working days from the date of inspection. So against that, my lord, I have submitted reply on 25/7/2016, Annexure 13, my lord, page 45. When I have stated all these things, why I have to submit that date of birth, which was cancelled later on. At page 45, my lord. Annexure 13. Respectfully, I beg to state that I am shocked and surprised to choosing me alone for issuing the above referred charge sheet dated 23/7/2016. Although instances are galore of the same nature in the university, which have already been settled by the university authority itself long time back, even by promoting such persons who had joined in to their services before attaining their 18 years of Yes, there are several persons, my lord. In my case, the matter was settled by correcting the date of birth in my service book on 6/11/84 without even raising any question of suppression or giving false information. As alleged now, and thereafter I was promoted to different post on verification of the relevant records. As such, it is quite unreasonable to reopen only in my case after about 32 years to make an inquiry regarding stale allegation. That in respect of the first allegation of submitting false information and suppression of factual information, I beg to state as follows. That in the year 1979, the University Authority had appointed several persons, including me, against grade 4 post on daily wage basis. The required qualification was considered, but the age factor was not seriously considered for appointment in grade 4 post in daily wage basis at the relevant time. I was appointed on 27/10/1979 as a peon in the university. As I was reading in class 8 at that time, I had obtained a certificate from the concerned headmaster and the same was submitted before the authority on believing the calculation made by the headmaster is to be correct. As such, I have never submitted any false information nor suppressed factual information as alleged in the charge sheet. During my service period, I was permitted to prosecute further study. Accordingly, I appeared in 1984 and could pass SSLC examination in 1986 only. As per admit card of the SSLC examination, my date of birth was recorded as on 21/2/1963. Accordingly, I had submitted an application for correction of my date of birth as per SSLC admit card. The said correction was made on 6/11/84 by the then registrar of the Guwahati University. It is necessary to mention here that there were several employees who were appointed like me initially on daily wage basis at the relevant time. They had also not completed 18 years of age at the time of their joining. In those cases, including me, the university authority exonerated or relaxed any lapses of the employees in furnishing information, and those matters were settled long time back by making correction in their service book. Thereafter, they were promoted even to higher post of superintendent of sections. The authority had never put any question to any of those employees. For instance, one Bhagavan Bora, who was initially appointed while he was 17 years, 6 months, he has been allowed all benefits. But in my case, the matter which was settled in 6/11/1984 has now been reopened unnecessarily with bias attitude, with discrimination. It is also stated that there is calculation wrong given in the charge sheet.
What happened after the disciplinary inquiry?
My lord, inquiry was held behind my back, my lord. That is also my point, my lord. Inquiry report was not supplied to me even after issuing the final termination order, my lord. It was submitted only after filing the writ petition before this honorable court, along with the affidavit in opposition. And in their affidavit in opposition, it is admitted position that the petition was denied the opportunity. Roshik may go to the affidavit in opposition filed by them, where inquiry report is there, my lord.
Did you ask for the inquiry report?
My lord, I do not know whether there was any inquiry or not. It was not known to me, my lord.
Then what is this memorandum?
Memorandum has
3/12/2018, page 54.
Here's your last paragraph, my lord.
Yes.
Whereas the reply furnished by Sri so-and-so in the charge sheet brought against him was not satisfactory, as per the opinion of the competent authority, an inquiry committee was, as stated below, was constituted with the following members by notification number so-and-so, dated 29/12/2016. That means 29/12/2016, they have constituted the inquiry committee. Thereafter, they have made certain communications to the petitioner, but nowhere it is stated that there was inquiry committee. As per their memorandum, on 29/12/2016, inquiry committee was constituted. But the earlier annexures, my lord, annexure 12/23/7/16, it was issued to the petitioner. In the charge sheet, they have not stated regarding inquiry committee. Thereafter, another letter was issued on 8/9/2018. In that letter also, so-called notice, no mention was there regarding the holding of inquiry, my lord, although it was constituted in the year 2016. My lord, next page may kindly be seen, my lord, that page 55. How the inquiry was conducted, my lord. Inquiry committee was constituted by following persons. At page 55, 3 persons. Against 1 person, I have submitted allegations regarding discrimination, but that person was made a member of that committee, my lord, after filing my objection on it. Thereafter, my lord, whereas the committee conducted the inquiry in the 3 sittings were there, but I was not informed, and noted following finding in its report submitted on 27/7/2017, with opinion that issue primarily can be decided on the basis of official records. Hence, personal appearance of so-and-so is not necessary.
Where?
My lord. Your Lordship, that page 55.
Oh.
My personal appearance was felt not necessary, although I was aggrieved.
Yes. Did the petitioner participate in the inquiry, Fukan?
My lord, I will submit my, my lord.
There's nothing in your affidavit.
My lord, he has not participated in person. That is true. But the retirement notice and the inquiry process, two different aspects. The
No,
retirement notice is not the outcome of that inquiry process.
No, that's why I'm coming to that point.
Yes.
The disciplinary proceeding, what was the outcome? What was the final outcome of that?
No final outcome as yet. Since, my lord, the matter has become sub judice. So Executive Council has not taken any decision as yet. Inquiry report has been submitted, and the EC has not taken any decision. Since 2019 onwards, my lord, it has become, my lord, sub judice before.
See, no, the issue is this. A departmental proceeding was initiated against the petitioner with regard to his submission of the
false misconduct, my lord.
Okay, let us say
Now, misconduct.
now until and unless the departmental proceeding culminates with an order,
My lord.
can you issue this order after retirement?
I'll submit on that aspect, my lord, with the authority, my lord.
Okay,
But for the time being, my lord, there are two aspects. One, finality of inquiry process. and second,
not
retirement.
complete.
Not complete. And it is not the outcome of that retirement impugn order, not the outcome of that inquiry process. Two separate issues.
Now the petitioner has already retired with effect from 2019,
2009.
correct?
Yes. ma'am. As per his version, he should retire in 2020. But as per our version, Miller, he should retire in 2019. Accordingly, he has retired, and this impugn order under Shellen is not the outcome of any inquiry report. Nothing. Not at all. It is clear from that annexure. Impugn order.
Because the disciplinary inquiry was to inquire whether whether the date of the petitioner
That misconduct,
is 1963 or 1959.
Miller.
Unless that decision is given,
Miller.
can you issue the retirement order?
But that is why, Miller, it is in the arena of misconduct. Giving false information.
Arena of misconduct, which
Yeah.
is under the cloud of the disciplinary proceeding, correct?
Miller.
That has not come to the final decision.
Not come to any final.
How did you issue this order?
Miller, since Miller, he has already Miller going to retire. He was going to retire in 2019. That is why.
Now, whether he is going to retire in 2019 would be the outcome of the disciplinary proceeding.
No, Miller, that would be Miller, that penalty, Miller, is to be imposed upon him, Miller, for his misconduct. It is not for retirement, Miller. The retirement aspect is totally different. I'll come to that, Miller, after submission of my. My lord, in that case, my lord, your lordship may kindly go through the affidavit at paragraph 15, my lord, affidavit in opposition. Second line, my lord. Considering the report of the inquiry committee, the university authority decided to issue the letter that is so and so informing the petitioner that his date of superannuation is so and so. So that means on the basis of inquiry, this action was taken. As per his statement, and per document, paragraph 15.
Your paragraph 15,
Inquiry is incomplete, my lord. In spite of that, my lord. Prior to that, my lord, paragraph 14. It should be read with paragraph 14. The first, second line, my lord. That very page, my lord. It was paragraph 14. University authority decided to take disciplinary action against the petitioner under Rule 46 and further informed. The second line, my lord, and further informed the petitioner that on attainment of 6 years of age, as per his date of birth, that is on so and so, based on his own declaration in his application dated so and so, submitted at the time of his initial appointment, his date of superannuation be considered on so and so. Accordingly, superannuation notice was issued to him on so and so by the memo number so and so. That paragraph 14 and 15 interrelated. It is true that in view of his false information regarding his date of birth, that inquiry, Miller.
how did you inform the petitioner?
Miller,
Did you inform him verbally or by way of communication?
by way of communication, Miller, that last paragraph, Miller, the last annexure, Miller, of read petition. Page 61, that office order. There is nothing about this inquiry report. Page 61, my lord. The date of superannuation of Mr. So-and-so on attainment of 60 years of age falls on so-and-so, and thereby he will retire from university service on 31/1/2019. The university will remain grateful to him for his
No, come to page 70 of your affidavit, para 14,
One line he has not read.
internal page 8.
Internal page 7, 14 onwards, my lord. May I read?
14, no, come to the next page.
My lord.
The petitioner under rule 46.
Of the Guwahati University Employee Service Condition Conduct and Appeal Rules 1970. Then, my lord, it is important. And further inform the petitioner that on attainment of 60 years of age as per his date of birth, that is on 8/1/59, based on his own declaration in his application dated so-and-so, submitted at the time of his initial appointment, his date of superannuation be considered on so-and-so. Accordingly, superannuation notice was issued to him on so-and-so.
No, accordingly, that is a different subject matter now.
My lord.
How did he inform the petitioner on top of that where you have said that based on his own declaration in his application, petitioner was informed.
My lord,
and then para 15, considering the report of the inquiry committee, university decided to issue the letter dated
my lord,
2018.
page 55, my lord. Page 55 of writ petition. The memorandum. There are two processes going on, my lord, simultaneously. One, that inquiry regarding false information, and another one is my lord, retirement process, my lord. 55 down below. Two paragraphs, my lord, down below.
Oh, this is a different thing. This is for his penalty.
My lord, first one penalty, then second one, my lord. May I read, my lord?
Read it.
Last two paragraphs, my lord. In view of the above sequence of events under rule so-and-so Guwahati University Employees Condition Conduct Appeal Rule, Sri Pavitra Kumar Nath is hereby served notice to submit his representation, if any, as he may wish to make against the penalties proposed to be imposed on him under Rule 46 of Conduct Rules, on the basis of evidence available and findings of the inquiry committee constituted to inquire into the matter. This is one part over, my lord, regarding inquiry. Now, second part. He is further directed, that is important, my lord, further directed to submit his representation, if he wish, why his date of superannuation from this university service should not be taken as 31 January 2019 on his attainment of 60 years of age, as per his date of birth, that is so-and-so, based on his own declaration at the time of joining in service under this university, particularly in his application dated so-and-so, while applying to the university for granting time scale to him in the post of peon, and which was subsequently considered by the university and time scale in the post of peon was granted to him with effect from 1/4/1980.
That's why, Furkan, this is the issue. There are two parts here. One is for penalty, one is for his consideration of his date of superannuation.
After that, my lord,
He met his reply.
my lord, he responded, my lord, after that, my lord.
After that, you should have passed an order.
My lord, after that, he responded, my lord, page 59.
That's it.
The last.
After that, have you passed any order?
My lord,
After that, have you passed any order?
prior to that, page 59, my lord. Last 3 lines.
Yes.
First, my lord, prior to that, my lord. 59, last 2 para. Therefore, I beg to state and submit that I had never deliberately submitted any false document in support of my age with a view to mislead the university, as has been alleged by you in your above noted office memorandum number so-and-so, for invoking Rule 46 and 48 of the Guwahati University Service Condition Conduct Appeal Rules. Further, I beg to submit the invoking of provisions of Rule 46 and 48 of the 70 rules in an instant case is completely out of context. This is one part. Now, next paragraph. Regarding the date of my superannuation, totally different, my lord.
Correct.
Regarding the date of my superannuation, I beg to state that my date of retirement is to be counted as per recorded date of birth in my service book as on 21/2/1963. The said date of birth was admittedly recorded on the basis of the admit card of SSLC examination. Next page, my lord.
which is regarded as the most authentic document for verifying age of an employee as per relevant laws in the field. Furthermore, the said verification was done by the university authority itself long time back on 6/11/1984 and acted upon it on giving even promotion to me on different occasions. As such, the said settled facts of more than 30 years cannot be reopened now to unsettle the same, that too on selective basis. The university authority has already waived its right to change or alter the said verification as my date of superannuation falls on so-and-so and not on so-and-so as alleged by you. Therefore, I humbly request your honor to finally settle the matter once for all by issuing necessary order for withdrawing the baseless charges leveled against me as indicated above. So, my lord, it is regarding
Two issues,
two issues, my lord.
penalty, superannuation.
My lord. That penalty,
So you have given him the notice, correct?
my lord,
You have given him the notice
my lord,
by that memorandum,
my lord,
and then he has made a reply accordingly.
my lord.
Have we passed a final order before issuance of that impugned order?
My lord,
Yes,
normally,
you are supposed to pass a final order
my lord,
because there are two issues involved.
my lord,
Unless you pass a final order,
my lord.
you could not have issued a superannuation order.
My lord, this is the final order.
Which is the final order?
The last page, my lord. That is the final order regarding his retirement. It is administrative discussion, my lord. But regarding the penalty aspect,
Have
he has
you
got the right.
have you disposed of this his reply by way of an order?
My lord, that is regarding, my lord,
That is the issue now.
my lord, since there are
There are
two
two
issues.
aspects, two aspects.
Retirement is not a penalty, my lord.
One is penalty,
My lord,
one is his date of superannuation.
my lord,
Through that memorandum, you issued him notice
my lord,
saying that under rule 46 and 48 or something of the Guwahati University rules,
my lord,
why penalty should not be
my lord,
imposed.
my lord.
Second paragraph, you say that you also asked to make a representation, I mean a reply,
My lord,
why your date of superannuation should not be taken for the year 1959.
my lord,
He replied,
my lord.
did you pass an order?
This is the order, my lord, office order.
Which order?
This office order, my lord.
That is not an order. That is an order of superannuating him.
That is why, my lord.
But have you passed an order to this reply?
My lord,
That is the issue.
my lord, that would be in the, my lord, regarding imposing of penalty, my lord. That would be before the executive council, and executive council has not taken any decision as yet, since the matter has become sub judice. But regarding that attainment of superannuation, that is completely administrative discretion, and after having the response from him, my lord, the authority has, my lord, responded with this office order, my lord. And I will, my lord, submit the authorities regarding this, and
Okay.
also SR, my lord.
But one thing you
first,
should
my lord,
keep in mind
my
that
lord,
the memorandum which
my
was issued
my lord.
has not been disposed of till now.
Yes, my lord, regarding that penalty, yes.
Not penalty, even superannuation.
My lord, my lord, I'll, my lord,
Even
submit
superannuation.
on that aspect, my lord. Regarding administrative discussion,
Because this office order of 31/12/2018
my lord,
is a normal order of superannuation.
my lord, that is why, my lord. But so,
It does not say that in so and so for this reason, we are considering your date of so and so as superannuation as so and so, and therefore you are retiring from that. If that is the wording in this order,
my lord,
then we can say that yes, you have considered the reply made by the petitioner.
my lord.
This is a normal or this is something else.
My lord, for every employee, my lord, that superannuation notice like this annexer office order dated 31/12, same, my lord. He has been given extra privilege, my lord. He has been given that extra, my lord, opportunity.
Okay.
My lord, anyway, my lord, I will submit on that aspect later, my lord, after submission of.
You know, that letter was issued, order was issued on the basis of considering the earlier date of birth recorded in the service book, not in the new entry, my lord, which was cancelled earlier by the authority concerned. And in their affidavit, they have specifically stated that this order was passed on the basis of an inquiry. But on the other hand, they have stated, admitted that the inquiry was not complete. So if inquiry is still to be completed, how they can take action on the basis of that inquiry, my lord?
Any more?
My lord. My lord, I have submitted the written argument, my lord, and certain case laws has already been referred, my lord.
Where the case laws?
My lord. First, my lord, 2011 1 GLT, page 520.
Page
520. My lord, I have given copy of those judgments, my lord. Probably it is there in the file.
Yes, yes. 2000?
2011 1 GLT.
Yes.
Division bench judgment, my lord.
Para?
For paragraph number 8, 9, and 10, my lord. During the course of argument, NC Das learned senior counsel for the appellants brought our notice to the annexer so and so, addressed the additional PF commissioner and PF scheme Guwahati letter so and submitted that when the respondent herein admits a mistaken entry of his age in the SSLC certificate, it would not be open for him to claim his date of birth as 8/10/49. This plea is nowhere found available in the counter affidavit filed by the appellants resisting the writ petition of the respondents, and thus no opportunity was provided to the learned single judge to look into the merit of this application that is so and so. This plea in our considered view cannot be allowed to be taken in the appellate stage of the proceedings. Even however, such plea of appellants cannot also take a base since such information was supplied by the respondent to the appellate authorities prior to the receipt of the communication dated so and so. Before communication of alteration, the letter and exercise was within the power and possession of the appellate authorities. But despite such information, so given the appellate authorities ignored it and altered the date of birth, thus the annexer for in our considered view cannot play a role in favor of the appellants. We find no sufficient proof. Contrary to the submission advanced by NCDAS learned senior counsel, Bhumik, JP Bhumik, learned counsel appearing for the respondents strenuously argued that since the appellant authority altered the date of birth from 13/11/45 to 8/10/49 on representation of the respondent, supported by valid documents such as matriculation certificate and birth certificate, and subsequent follow-up action by the appellant authorities basing on such documents, it would not be justified on the parts of the appellant to place an argument that such alteration of date of birth was made without verification. In this present case also, they have stated that entry was not made properly in the service book. So it was rejected by the division bench. From the facts appearing in the face of the record, we also noticed that on the basis of the altered date of birth, the respondent obtained various benefits while in service, and such benefits cannot be allowed to be disturbed by accepting the case of the appellant. In our case also, my lord, Several benefits were given considering the new entry, my lord. We have given our just consider.
Let us.
Yeah.
Next case.
Next, my lord. 2006 4GLT. For GLT page 38, my lord.
Yeah.
May I read the headline, my lord?
Give me the relevant part of it.
Paragraph 4.
Yeah.
12. Seventeen. 21. 26 and 28. In this case, my lord, on the basis of action was taken on the basis of the cancelled or already discarded entry, my lord. That was not allowed, my lord. In the present case also, that entry was discarded or cancelled, and subsequent entry was there in the service book, but effect was not given. That was not allowed by the court. Next, my lord. Nineteen 84 to SCC. On the same line, my lord.
Para.
Still, paragraph 14 and 16. The stale entry cannot be taken into consideration. In my written argument, I have stated those things, my lord.
You have not stated the para.
Paragraph 8 and 9, my lord. Of this 84 to SCC. 84 to SCC. Page 8. Paragraph 8 and 9. On the same principle, my lord.
Okay.
Paragraph 8. From what has been stated, we find that the decision taken by the High Court in respect of the appellate is arbitrary, as it was mainly based on the entries that were made.
1984.
1984, my lord. 2 SCC.
8.
8, my lord.
Para 8.
Para 8.
The above reports.
Yes, my lord. In the lower part, my lord, observation. From what has been stated, we find that the decision taken by the High Court in respect of the appellant is arbitrary, as it was mainly based on the entries that were made 20 years before the date on which this decision was taken. Dependence on such stale entries cannot be placed for referring a person compulsorily, particularly when the officer concerned has been promoted subsequent to such entries, as held by this court. So in my case also, different promotions and different benefits were given to the petitioner after that entry, making that entry. Next, my lord, 2007 2 GLT. 2007 2 GLT. page 74, paragraph 4. The petitioner has stated after passing the matriculation exam in year so and so. Paragraph 4, my lord. Under the aegis of the university with roll number so and so, he was issued a certificate bearing number so and so, in which date of birth was recorded as 1345. As it was incorrect, the petitioner's actual date of birth being 1947, he applied before the competent authority of the university for concern correction thereof. In response to this application, his date of birth was corrected on 1947 in the said matriculation certificate. The same date of birth was accordingly recorded in the agreement, as well as his service book of the petitioner, which was opened on 28/4/1992. The identity card issued by the university to him, the date of his retirement was mentioned as so and so. So in my case also, date of retirement has been given in different communications, my lord. Next, my lord, 2003, 3 GLT. 2003, 3 GLT is 393.
2003.
2003, 3 GLT. Paragraph 5, my lord. Paragraph 5. From middle part, my lord. It is at this stage that the university authority decided to go back to the records already available with them and reach the conclusion that the date of birth of the petitioner is 1/1/1935. The records reveal that the aforesaid conclusion was reached by the university on a reconsideration of the existing facts, which were earlier discarded by the university authority, who had opted to send the petitioner for medical examination. So already discarded entry was considered, my lord. That apart, in the process of such risk.
Okay.
Yes. Next, my lord, 2001, 2 GLT, page 175.
What?
Paragraph Paragraph 6, my lord. Paragraph 6, 7, and 8. So in paragraph 6, my lord, in this case also, they have raised that question that he was below 18 years at the time of his initial appointment, just like the present case, my lord. It was not interfered by this honorable court, my lord.
Six.
6, 7, 6 and 7, my lord. Next, my lord, 2015, 4 GLT, 137. Lord, this matter has been referred, case has been referred for giving his consequential benefit, my lord. Paragraph 22. In this case also, there are several communications. Official communication from the university concerned showing his date of retirement, just like the present case, my lord. And the matriculation certificate, they have not doubted it. They have not challenged it. So the court held that it is to be held as regular or valid one. Next, my lord, 2005 3 GLT is 257. Paragraph 31 and 33, my lord, for giving the consequential benefit, because he was prevented from rendering his service. So he is entitled to get his salary for that period. The same point, my lord, under reference to 2012 1 SCC. Page 674. Last paragraph, paragraph 21 is important. Consequential benefit, my lord. Next, my lord, 2016 SC 157, year 2016.
2016.
16, one page only, my lord, small. 2016 SC
That is 30. Okay, yeah.
157. There is no work, no page, not applicable in this case, my lord.
Yeah.
The same point, another decision. 2017 3 GLT Meghalaya. Similar point for area PM. Lastly, my lord, regarding non-application of non-supplying of this inquiry report, my lord, which is mandatorily required to be
Yes.
My lord, lastly, my lord, the inquiry report was not applied to the petitioner,
Yeah.
which caused prejudice to the petitioner. Supporting case laws, my lord. The first case is 2016-1 ZLJ, page 663. My lord, in Assam Service Discipline and Appeal Rules 1964, similar provision is there to supply the inquiry report. In this case, inquiry report was not submitted before imposing that punishment. So it was held that the inquiry is illegal. And on similar point, under next, this is submission, next case law, my lord.
Are you challenging the disciplinary proceedings?
Proceedings, I have selected that order, my lord. So my humble submission is that as per the admitted position, my lord, in the affidavit as well as the from the verbal submission, inquiry is not complete. From the inquiry report itself reveals that they want to obtain certain informations from certain other authorities. But it was not obtained admittedly. And from verbal submission also that inquiry is not complete. But from their affidavit in paragraph 15, they have specifically stated that the action was taken, the order was issued on the basis of the findings of the inquiry committee. So it is, my submission is that order is quite illegal. So necessary order may be passed by your lordships for setting aside that order, and consequential benefits may be given to the petitioner.
Look, first of all, Miller, I take your lordship straight to the service record. Annexure 2, Miller. Page, it starts from page 22 to 24. Read petition, Miller. Miller, the relevant portion is at page 23. Typed version. Typed version of page 24. Married. Date of joining 1480. The age of Sri Pavitra Kumar Nath, 20 years, 0 month, 10 days, according to the admit card issued by SEBA. And while verifying the age, his date of birth is found to be fallen on the 21st of February 1963. His admit card number so-and-so of 1983. Date of birth according to admit card. Milord, the officers, Milord, putting their signatures are important, Milord. In the right-hand side, Milord, it is Deputy Register Administration. And the down below, Superintendent General Branch. Next page 24, it is clear, Miller. Down below it is Deputy Registrar dated 6/11/84. And left side Superintendent General Branch, Guwahati University. Not the register, Miller. It is Deputy Registrar and Superintendent. Now, kindly turn to FRSR, Miller.
Fukan, that page 24,
Miller.
on top where you accepted 8/1/1959,
Miller.
that is also not signed by the registrar.
Miller, at the time of correction, that is why Miller FRSR would be required. At the time of alteration or correction, the signature of register is required. So, Miller, if I take your lordship straight to SR 8, Miller, then the legal provision will be clear. SR 8.
SR.
SR 8. এখন video can be seen. Is the better, Miller? Photocopy, Miller. SR 8 regarding the alteration of date of birth. SR 8, we can skip 8A and B. And next page, Miller, C. SR 8 C. Next page. Mary. Commissioner and heads of department, here Miller register me, may alter the recorded date of birth in the case of non-gazetted government servants, provided they are satisfied after inquiry. There are two aspects. One, register. Second, inquiry. That the previous date was incorrect. Now we can skip the note, Miller, then down below, Miller, last paragraph. The following criteria should be followed in considering requests for change in date of birth, which are not time-barred. Such requests should be supported by satisfactory documentary evidence, such as the matriculation or equivalent certificate or duly attested copy of birth certificate, together with a satisfactory explanation of the circumstances in which the wrong date came to be entered, and statement on any previous attempts made to have the record amended. Now it is important. The last 4 lines, Miller. Page 22. It should also be examined whether the government servant concerned would have been within the age limits prescribed for government service at the time he entered service, with reference to the different date later claimed by him as the correct date. If he would not have been so eligible, it should be examined whether the date actually accepted then was given by him bona fide and did not give him some advantage in securing admission into service at that time, and the change proposed later on is for bona fide reasons and not merely to gain some fresh advantage. He entered at 16 years of age. He got time scale at 17 years of age, and the entry age should be 18 years as per Service Condition Act rules. So, Miller, the two things is clear, Miller. One, the age, alteration of age or correction of age should be by the registrar of the university, not deputy registrar or superintendent. First. Second, it should be after an inquiry. That is clear from HC. These 3 lines. Commissioner and heads of department may alter the recorded date of birth in the case of non-gazetted government servants, provided they are satisfied after inquiry that the previous date was incorrect. And he should not gain any advantage, Miller, the last paragraph. After 16 years, Miller, he got 2 years of service, but he should have been admitted at 18 years of age. Both ways, He is the gainer. Now, my lord, my written argument, my lord. That will shorten my lord, submission, my lord. I have already given the written arguments, my lord, written note of argument as per earlier court's directions, my lord. 3 pages arguments, my lord, along with authorities. First paragraph, my lord. May I read, my lord? Though the petitioner claims his new date of birth is on 21 February 1963, instead of earlier recorded date on 8 January 1959, he could not have joined Guwahati University as daily wage worker on 2/4/1979 at an age of 16 years, 1 month and 11 days, and could not get time scale in the post of peon on 1/4/1980 at an age of 17 years, 1 month and 10 days. 18 years being the minimum age for appointment as per Rule 5.3 of the Guwahati University Employee Service Conditions, Conduct and Appeal Rules 1970. As per Rule 5.3, my lord, it should be 18 years. He has been, my lord, he entered at an age of 16 years, 1 month, 11 days. Now, para 2. As per the petitioner's representation dated 10/12/2018, Annexure 17 to the writ petition, page 57 to 60, his date of birth was verified and corrected as on 21 February 1963 on the basis of SSLC admit card, which was approved by the then Deputy Registrar Administration, Guwahati University on 16/6/11/1984. 11/12 line of page 59 writ petition. Also, this annexure 2, page 24. Your lordship has already, my lord, perused. A. However, as per SRHC, read with the note appended thereto, it is provided that commissioner and heads of departments may alter the recorded date of birth in the case of non-gazetted government servants, provided they are satisfied after inquiry that the previous date was incorrect. As such, in the instant matter, next page, my lord, there are 2 clear conditions for date of birth alteration correction process. Firstly, the alteration correction should be made by the head of the department, that is by the registrar of the university himself in the instant case. And secondly, it should be after an inquiry. Not a single condition is fulfilled in the instant matter. No inquiry and not by the registrar. It is by the superintendent and the deputy registrar administration. Now B, it is important. Further, as per the Honorable Apex Court's judgment rendered in Puranjit Singh versus Union Territory of Chandigarh and others, 1994, Supplementary 3 SCC 471, para 11, it is clear that notings in the departmental files did not create any rights in favor of the employee concerned. Rather, it is the orders issued by the competent authorities and received by him which alone create rights in his favor. In this regard, 2013-16 SCC 147 may also be referred to. It is by Union of India versus Ashok Kumar Agarwal. My lord, I may be permitted to, my lord, that this authority, my lord, Ashok Kumar Agarwal, it is subsequent to this Puranjit Singh. Puranjit Singh is 94.
Have you supplied the copy, Puranjit?
Yes, my lord. Earlier I have supplied, my lord. If it is not there, my lord, I have a copy, my lord.
Yeah, the adjustments are there on the file. There are no more adjustments.
I have given all the authorities also, my lord, that service condition, my lord. This Puranjit Singh, 94, paragraph 11, my lord. Notings in the files won't create any, my lord, right to the employee. That notings in the service book, my lord, as per page 24, notings by the superintendent as well as the deputy registrar won't create any right. It should be succeeded by an order.
Okay.
My lord, then this Ashok Kumar Agarwal, my lord, para 33 to 38, my lord. May I read, my lord? Para 33 to 38. Ashok Kumar Agarwal case, 2013. Much later to this Puranjit Singh. Para 33. The instant case is required to be considered in light of the aforesaid settled legal proposition, statutory provisions, circulars, etc. The tribunal inter alia had placed reliance on notings of the file. The issue as to whether the notings on the file can be relied upon is no more res integra. Now, paragraph 3. Negative equality. The petitioner is not entitled to any right vis-a-vis the other similarly situated employees, it being the forbidden area of negative equality, which is not acceptable under the provision of Article 14 of the Constitution of India as per judgments rendered in Kustan Nibarok GSSMM, Indore versus President, Indore Development Authority. 2006 to SEC 604 para 8. Lord, para 8. Under Article 14, that negative equality aspect in Indian Constitution. Now, paragraph 4. Paragraph 4, Milord. It is most important, Milord, in an order judgment of the division bench, Milord. In a similar case, a division bench of this honorable court has rendered judgment in Swadesh Ranjan Day versus State of Tripura and others, 1999 1 GLT 45, para 567, upholding the single judge's findings order that the declaration of date of birth, next page, Milord, as given by the petitioner at the time of entry in the government service shall prevail, and the date of birth reflected in the admit card and the school final examination certificate cannot unsettle the said declaration. Milord. Swadesh Ranjan Day versus State of Tripura and others. Division bench judgment, Milord. It will clarify, Milord, the entire scenario, Milord. The legal backdrop, Milord. Para 5, 6, and 7. May I read? Para 5. The learned single judge, taking into account all the circumstances made available before him, and also after a careful consideration of the entries in the service book, held that the age recorded in the admit card and the school final examination certificate is of no significance, as the petitioner had appeared in the school final examination long after his entry to the government service. Similarly situated. The learned single judge also came to a finding that the petitioner had himself declared his date of birth as in March 1938, and this declaration has been signed by the petitioner as well as the Circle and Assistant Settlement Officer of the Survey and Settlement Department, Government of Tripura on 16/5/1960. On this finding, the learned single judge held that the declaration of date of birth as given by the petitioner at the time of entry in the government service shall prevail, and the date of birth reflected in the admit card and the school final examination certificate cannot unsettle the said declaration. Next parameter, para 6. On a careful consideration of the copy of the relevant entry in the service book, annexure so and so, we are convinced that the date of birth was initially inserted as March 1938 in the service book, and it was signed by the petitioner in approval thereof. Later on, in the year 1966, the date of birth was corrected by the respondent on the basis of a school certificate produced by the petitioner reflecting 21/1/1936 as the date of birth. Thereafter, the petitioner passed the school final examination as a private candidate in 1967, and in the certificate issued by the West Bengal Board of Secondary Education, now here Milord Seba, altogether a different date of birth, that is 30/12/1940 was reflected instead of 1936. The earlier recorded date of birth was again corrected, and 30/12/1940 was inserted as his date of birth. Because of 3 different dates of birth figuring in the service book, the department considered it appropriate to examine the matter and directed the writ petitioner to produce documentary evidence for the purpose of verifying the same. The director so-and-so, Government of Tripura, by the order number so-and-so, dated so-and-so, disposed of the matter finally after taking into consideration the representation dated so-and-so submitted by the petitioner, holding that the date of birth of Sri Swadesh Ranjan Day should be treated as March 1938 for the purpose of determining his age for superannuation within the meaning of FR 56, since it was declared by M at the time of entry to the service. It would appear that the date of birth, that is March 1938, recorded in the service book on the declaration of the petitioner, has been accepted and acted upon by the respondents. This was so necessary because of the confusion created by different entries on different occasions regarding his date of birth. Obviously, the date of birth as per school certificate and the date of birth as per admit card school final examination certificate could not be accepted by the respondents. Now we can, my lord, skip the other.
Yeah, I've got it.
Now, my lord, paragraph 5. The petitioner got retired on 31/1/2019 on attainment of 60 years of age, which incident of retirement is not a penalty under Rule 46 of the aforesaid rules of 1970. As per the impugn office order dated 31/12/2018, Annex 18 to the writ petition, page 61, not in view of any inquiry as projected by the petitioner. That inquiry process and that superannuation process to different aspects. My lord, before superannuation, my lord, no show cause should be given, my lord. Otherwise, my lord, it should be in the administrative discussion. Otherwise, my lord, the entire system will go astray, my lord. So cause, then inquiry, then search it, my lord, such things will come up, my lord. It's a routine manner, my lord, administrative discussion. If his date of birth is 2019, then my lord, his 1959, then he should go in 2019. Then paragraph 6. The inquiry committee's findings have not been given effect to and no penalty has been imposed upon the petitioner as yet, wherein his challenge to the inquiry process would be under touchstone of prejudice as per the State Bank of Patiala versus S.K. Sharma case.
But what about your para 15?
My lord, I'll come to that. Further, most significantly, the said inquiry and the impugn retirement order are two separate processes, my lord. Now, my lord, first, the petition, my lord. I have already, my lord, shown the lines, my lord. In spite of that, my lord, I'll again, my lord, show your lordship page 55, down below. Since it's a very vital aspect of the entire matter. Page 55. It starts from page 16, page 54, my lord, Annex 16. It's a memorandum issued on 3/12/2018, prior to that superannuation impugn order. Page 55, down below. Before that, my lord, down 2 paragraphs, my lord. In view of the above sequence of events under Rule so-and-so, Sri Pavitra Kumar Nath is hereby served notice to submit his representation, if any, as he may wish to make against the penalties proposed. It's regarding his submission of his representation against the penalty proposed.
That's a different thing.
My lord,
Come to the
right,
next
now
paragraph.
next para. He is further directed to submit his representation, if he wish.
He did.
Yes, my lord. Why his date of superannuation from the university service should not be taken as 31/1/2019 on his attainment of 60 years of age as per his date of birth, that is 8/1/1959, based on his own declaration at the time of joining in service under this university, particularly in his application dated so-and-so, while applying to the university for granting time scale to him in the post of peon, and which was subsequently considered by the university, and the time scale in the post of peon was granted to him with effect from 1/4/1980 by the office order dated 1980. It is way back in 1980. Now his reply, Milord.
That also I've seen.
Milord. Page 59, Milord, down below.
Yeah, I've seen.
So, Milord, that penalty aspect he has represented by Annexure 17, Milord. It is dated 10/12/2018. Just 6 days, Milord, after this memorandum, Milord. Down below at page 59. Regarding the date of my superannuation, I beg to state that my date of retirement is to be counted as per recorded date of birth in my service book as on 21/2/1963. His version is that his date of birth is 1963. But our office memorandum indicates it should be 1959. Now his version is that it should be 1963. The said date of birth was admittedly recorded on the basis of the admit card of SSLC examination, which is regarded as the most authentic document for verifying age of an employee as per relevant laws in this field. So as per his version, since it's a matriculation certificate, so it should be regarded. Gospel truth, Milord. Nothing more, Milord. Since SSLC admit card, so it should be admitted. Furthermore, the said verification was done by the university authority itself, university authority. That means the superintendent, as per his version, the superintendent as well as deputy registrar is the authority, but they are not authority. Long time back on 6/11/1984, and acted upon it on giving even promotion to me on defined occasions. As such, the said settled facts of more than 30 years cannot be reopened now to unsettle the same, that too on selective basis. The university authority has already waived its right to change or alter the said verification, as my date of superannuation falls on 28/2/2023 and not on 31/1/2019 as alleged by you. So, Milord, his version is completely go against in violation of SR 8C. No inquiry, no indication of any signature by the register. Then, Milord, his version has been considered and his final order has been issued, not in view of the inquiry report. Since, Milord, that office order has not, Milord, indicated nothing, has not indicated anything about this inquiry report or entire, Milord, that office memorandum and other things, Milord. It's a simple routine manner, Milord. The date of superannuation of so-and-so falls on so-and-so, thereby he will retire from the university service on so-and-so.
That's why I'm asking you one question. You have not been able to answer it.
Milord.
After the reply, what final order was passed?
That is the final order, Milord.
Which final order?
This impugn order, Milord.
You are saying that the impugn order is not based on the inquiry report.
No, Milord. Inquiry process and report, different aspect, and the routine manner, administrative discretion for retirement, Milord, it's another, Milord, aspect.
What about the memorandum? Where you asked him to answer on two issues.
One issue, I'm again repeating, Milord. One
What
issue
issue?
is regarding
I've got
penalty.
it. Penalty. Second issue is superannuation.
It is not a penalty. Since it's
It-
not a penalty, he has been asked to represent, Milord. Since, Milord, there something is there, Milord, the deputy registrar as well as superintendent has corrected in the service book.
See, the whole issue is this. Initially, departmental proceedings started on a definition.
Misconduct.
On misconduct.
Misconduct.
Then you issue that memorandum
Milord.
on the basis of the inquiry report. Correct.
Milord.
There you made a mess by clubbing two things, that is the penalty and this state of supervision. Then he was asked to reply. He replied for both. Now where's the order? Where's the order?
Milord, regarding that clubbing, Milord, I agree, Milord. Since, Milord, that penalty memorandum and this
If you had proceeded straight on the basis of the departmental proceeding
Milord,
as per the show course,
Milord,
that this court would have accepted that part.
Milord,
That you have not given a final decision to the inquiry report.
Milord.
But then when you issued the memorandum proposing the penalty and also on the superannuation, you clubbed two things. Then he answered to both. Now you should have at least brought to the final order. On the basis of the final order, if you have issued a superannuation order, this court could have accepted that part.
Milord, regarding Milord that clubbing of two aspects, two issues, Milord. Milord, that penalty aspect, it has not been given finality by the Executive Council.
No, when
Since
they,
Milord, the entire matter has
when the memorandum clubbed two issues,
Milord,
the penalty and the debt of superannuation.
and he has also admitted, Milord. He
No,
also
he has-
responded.
He replied.
He
He
also
he responded
responded.
because you directed him or you told you asked the petitioner
Milord.
that he may wish to reply on these two issues.
So he also, Milord,
He
considered
made his reply.
first issue, Milord, that regarding penalty, and second, Milord, the opening line is with furthermore, Milord. Since, Milord, we have directed him to represent, Milord. So he, furthermore, he also responded.
That's why, no, where's the order?
Milord, that order,
Disposing of that furthermore.
Milord, since, Milord, I again, Milord, repeating, Milord, since, Milord, that penalty representation disposal, Milord, process should be with the Executive Council. And the matter has come before this honorable court. Matter has become sub judice. So on that part, Milord, the Executive Council is silent
Okay.
as yet, Milord.
Okay.
But regarding the superannuation process, since it falls under the administrative discretion, it's a routine manner. And he has again taken that earlier stand in violation of SRHC. Then
So
what the authority will take, Milord?
Mr. Foucault,
His
one side you say departmental proceeding on the issue of misconduct
Milord,
and superannuation is a routine manner.
Milord.
But why did you club up these two in that memorandum, which was issued on the basis of the inquiry
Milord,
report?
On that aspect, I agreed, Milord. There should be two.
That is
Milord,
what I'm
notification.
asking. There should have been two.
But he doesn't have any legal right against that routine manner administrative discretionary process, Milord. We have given him that privilege, extra privilege, so that he could come out with some explanation.
You could have issued a separate memorandum.
That is, Milord, one aspect, Milord. I agreed, Milord.
You
But
could not have clubbed up two.
But that is why, Milord, that paragraph 7 would be important, Milord. My written argument. May I read, Milord? That will, I think, Milord, that is the last paragraph. The petitioner, without submitting an appeal against the impugn retirement order dated so and so, as per Rule 53 of aforesaid rule of 1970, is not entitled to move a writ petition under the existing laws.
What is
So, Milord,
1970
Milord,
rules?
I have given the, Milord,
No,
rules.
just say what is the 1970 rules?
70 rules, Rule 53, Milord.
No, the
Appeal against orders, Milord.
appeal
If
against
he is
orders of
equipped-
which order?
Milord, regarding this retirement order, Milord, any service condition, Milord, one can move an appeal, Milord. It's a statutory provision. If he is aggrieved, Milord. he
Let
is
us see. Let us see.
Rule 53, Milord.
That one I don't have that book. What is it called?
My lord, I have given one copy, my lord.
This one. This one.
Yes, my lord.
Conditions, conduct and appeal rules.
Yes,
Milord.
1970.
Milord. Rule 53, Milord.
Rule 53.
When did you look at copy? He did.
No, I have it here. I've got it. Here.
Didn't have. Milord, in that type copy, Milord, it is 52, Milord.
Yeah, it
Here,
is.
Milord, 53, Milord. Is printed.
I think anyway.
52 here, Milord, 51 appeals, 52 appeals against order imposing penalty and 53 is appeal against orders.
Yes.
Possibly there 50 is regarding appeal, 51 appeal against order imposing penalty and 52 appeal against order. It is relevant minute 52 as per type copy, as per printed copy, it's 53. An employee may appeal an order which denies or varies to his disadvantage his pay, allowance, provident fund, gratuity, pension, other conditions of service as regulated by any rule or by any agreement. Other conditions of service, Miller. That retirement, Miller, falls under that condition of service, Miller. Retirement is a condition of service. Interprets to his disadvantage the provisions of any such rules or agreement to the authority to which the authority passing such order is immediately subordinate. So he should have appealed before the Vice Chancellor, since the impugn order has been issued by the Registrar, Miller. So superior to the Registrar, the Vice Chancellor. So without filing any representation, any appeal, he straightway comes to this honorable court with this petition, and since 2019 onwards, it is pending.
Okay.
So at least on that exercising that rule 53 or rule 52, that appeal provision, he should have come against the impugn order.
Now, what do you say on the departmental proceedings?
It will, after this matter, comes to a.
No, he's challenging the departmental proceedings.
Millard.
The show cause notice.
Millard. Since it's not, has not been given any finality as yet, Millard.
One issue is this.
Millard.
That he has not been permitted to participate in the departmental proceeding.
Millard. So he must show the prejudice, Millard. Since as per this SK Sharma case, Millard, he should have shown his prejudice, Millard. Since it's only documentary, Millard, that school certificates and other things, Millard. So his personal presence is not required by the inquiry committee. Anyway, Millard, I am not on that aspect, Millard.
No, he is challenging the two issues involved in this writ petition.
He has clubbed, Millard. His stand is that on the basis of inquiry report, Millard, his retirement order has been passed. But my stand is that inquiry report and inquiry process, as well as that retirement process, two different aspects, totally different.
How do you wipe out paragraph 15 of your affidavit?
And then paragraph 19 and 14, Millard, all should be read together, Millard.
Yes.
Paragraph 19, Millard, of my affidavit.
Paragraph 19 or
19.
14?
14 and 19, Millard. First, Millard, paragraph 14, Millard. I'll again read, Millard. It starts from page 7, Millard. It should be clear, Millard. Paragraph 14, Millard. That your deponent denies the statements made by the petitioner in paragraph so-and-so of the writ petition and states that the allegations leveled against the respondent number 3 by the petitioner are false and baseless, as the inquiry committee was constituted with following members so-and-so, the presenting officer. The committee, after inquiry, found the petitioner guilty of concealing his actual date of birth. Therefore, the university authority decided to take disciplinary action against the petitioner under Rule 46 of the Guwahati University Employee Service Conditions, Conduct and Appeal Rules 1970. So that disciplinary proceeding started. Charge sheet has been framed, inquiry report has been submitted, but EC has not taken any decision, so it has not got that stage of finality. And it is important. And further inform the petitioner that on attainment of 60 years of age, as per his date of birth, that is on 8/1/1959, based on his own declaration in his application dated 8/3/1980, submitted at the time of his initial appointment, his date of superannuation be considered on 31/1/2019. Accordingly, superannuation notice was issued to him on 31/12/2018 by the memo number so-and-so. So, Millard, as per this paragraph 14.
Paragraph 14 is you are referring to the memorandum.
Memorandum, Millard, and Millard, my lord, the impugn order, my lord. The last
Oh, That's why.
3112.
First,
Then
is you are referring to the memorandum.
first memorandum.
After
and,
that, the order.
and further informed.
Hmm.
That is important, my lord. That further word.
The further
It
informed.
will, my lord, interpret the entire things into two.
No,
two
this
aspects,
this will have to be read with the memorandum. Correct.
my lord.
He issued.
Issues, my lord.
After that, you asked him to make his reply. He made his reply.
But it is in another separate, my lord, paragraph. But I agree, my lord, that both should not be clubbed together.
That's the
But
thing.
since, my lord, is another paragraph, and that opening word, furthermore, my lord. So, my lord,
In a memorandum, there are 4-5 paragraphs.
my lord.
Just because that paragraph is there, separate paragraph is there in that particular memorandum.
My lord, a
Can you
separate,
say that it was a different memorandum?
my lord, since, my lord, the earlier paragraph ends there, my lord, that penalty would be imposed upon you.
No, don't make that type of submission, Fukon. The
That-
paragraph ends with the last page, not with that paragraph, the memorandum.
That is why otherwise, my lord, that word furthermore would not have been used, my lord. Anyway, my lord,
No.
now paragraph 19, my lord, my affidavit,
Why don't you
Next
read
page.
15 first?
my lord. Paragraph 15, my lord. That your deponent denies the statements made by the petitioner in paragraph 20 and 21 of the writ petition and states that the petitioner never applied for correction of his date of birth and his date of birth was not corrected as claimed by him. Considering the report of the inquiry committee, the university authority decided to issue the letter dated 31/12/2018, informing the petitioner that his date of superannuation is 31/01/2019. My lord, then, my lord, paragraph 19, my lord.
Explain paragraph 15 first.
My lord, since, my lord, the paragraph 15, 14, and 19 all should be read together, my lord.
Okay, but then let us go step by step. Para 15, you explain what is there in para 15.
My lord, the
It
report,
says on the basis of the inquiry report, you issued a supervision notice.
but the report of the inquiry committee has not been, my lord, finalized by the executive council under the law,
This is an affidavit.
my lord.
This is an affidavit.
Affidavit, my lord. But this affidavit, vis-a-vis the legal, my lord, provisions, my lord. That
Then
SR,
are you saying
my lord.
that this particular deponent,
My lord, if one picks up only one line and forgets the other lines, then, my lord, the interpretation and vis-a-vis the context of the
it
legal
is a
provisions,
sworn affidavit, Mr.
sworn
Fukon.
affidavit, my lord, but the other sentences,
Okay, we are going to the other sentence.
which sentence will get primacy, my lord? This only
That is
one
what-
line,
Para 15 also I want to know
My
what
lord.
is there.
but paragraph 14 and 19, I will, my lord,
14 memorandum,
my lord.
correct?
Not only memorandum, my lord.
Memorandum in the notice.
My lord, I will have to go to the writ petition first, my lord, since, my lord, it is in context of the writ petition, my lord, paragraph 18 and 19, my lord.
Okay, read.
My lord. That will clarify the position, my lord. Paragraph 18 and 19, my lord. In the context of paragraph 18 and 19, this paragraph 14
Yes,
has been,
yes, that is correct.
may I read? I'll go slow, my lord. Paragraph 18, my lord, writ petition. That from the office memorandum dated 31/12/2018, Annexure 16, it is clear that the university authority had appointed as 1 minute. My lord, this is, my lord, little, my lord, that 31/12/2018.
Hmm.
Annex, my lord, there is no 31/12/2018 Annexure 16. If we pick up this sentence, my lord, the entire writ petition will go, my lord. My learned friend is pointing only one sentence of the affidavit. But if I may be allowed, my lord, this first sentence, my lord, where is Annexure 16 dated 31/12/2008? You would say that it would be a
312, my
typographical
lord.
mistake.
Typing mistake, 312, my lord.
Then in my case, It
Is
cannot be a
50
typographical mistake, my lord.
54, my lord.
How can it be, my lord? 31/12/2018 is the impugned retirement order. Twice, my lord. Date is wrong, annexer is wrong, and this is the opening line.
Annexure 16 is 3/12/2018.
312.
That is why, my lord. Why 31/12, my lord? My lord, now next line, my lord. I agree, my lord. It is a typographical mistake. But in my case, my lord, I must be, my lord, vigilant enough, my lord. Anyway, Office Memorandum dated 3/12/2018, Annexure 16. It is clear that the University Authority had appointed Respondent 3 as one of the members of the purported Enquiry Committee with ulterior motive and malafide intention only to deprive the petitioner from his due. The said fact is further buttressed by the opinion given by the purported committee in holding and observing that the issue can primarily be decided on the basis of official record and personal appearance of the petitioner was not necessary. The fact clearly shows that the petitioner was debarred from appearing in person before taking any adverse steps against him, which is a clear case of violation of the principle of natural justice. So, Miller, it is regarding enquiry aspect. Next paragraph, subparagraph. As such, any action taken against the petitioner on the basis of the report of the purported enquiry committee is not sustainable in law. However, the authority has asked the petitioner on the basis of the said report to submit his representation to show cause why he should not be penalized as per provision of law. So, my lord, it's a total misinterpretation of that Annexure 16. It is clearly regarding the earlier paragraphs, not the last paragraph. That furthermore paragraph is not here. It is regarding only on the enquiry process, that respondent number 3, biasness, etc. Now, paragraph 19. On the basis of paragraph 18 and 19, Miller, my paragraph number 14 is
Read para 19.
that the University Authority by the above noted office memorandum has further asked the petitioner to submit his representation as to why. Again, that word, Miller, further asked the petitioner to submit his representation. He himself admitted, Miller, in next parameter. Further asked the petitioner to submit his representation as to why his date of superannuation shall not be taken as on 31/1/2019, considering his date of birth as on 8/1/1959. Next para, subpara. Be it stated that the date of birth of the petitioner was already duly corrected and verified on so and so, as stated above by the competent authority. Thereafter, it was considered each and every time for giving promotion and other benefits to the petitioner. However, at the verge of retirement, the University Authority has been trying to give effect to his date of birth from another date which has already been settled for more than 30 years without putting any question. Hence, the authority is acted quite arbitrarily without any basis but with malafide intention. So, paragraph 18 is regarding inquiry, and paragraph 19, as per his understanding, as per his comprehension, Miller, a totally different thing than that inquiry process. Here, Miller, nothing, Miller, is indicated that this superannuation process is on the effect of the inquiry report. And he used that word further, used that separate paragraph, Miller, altogether, with two subparagraphs, Miller. On the basis of that 18 and 19, I have, Miller, responded in paragraph 14.
That we have seen.
With that further word, Miller, further inform the petitioner. So there are totally different, Miller, aspects, and his interpretation is also on the same line, Miller. One is regarding penalty, another that routine manner, that superannuation aspect. Now, Miller, paragraph 15, Miller. Paragraph 15 is on the basis of paragraph 20 and 21. May I read, Miller?
Read.
Short paragraph. Paragraph 20 of the writ petition. In response to the above noted memorandum, the petitioner has submitted his representation on 10/12/2018, stating that he had never submitted any false information or document in support of his age as alleged, He has further stated that his date of birth has duly been verified and correctly recorded by the authority on the basis of most authentic document, that is admit card of SSLC examination, which was further authenticated by the deputy registrar and the registrar themselves. So it is, my lord, misleading statement, my lord, register themselves. Only the deputy registrar and superintendent, not the registrar. It's a misleading, my lord, statement. Anyway, my lord. The said correction, I still regard it as typographical mistake, my lord. The said correction is still in existence, as no further correction has not yet been made. Accordingly, the petitioner has submitted that his date of superannuation should be calculated, holding his date of birth as on 21 to 1963 as per relevant note and record in the service book of the petitioner. So, my lord, it is this paragraph is regarding, my lord, his verification of date of birth and not about anything regarding that inquiry report. My lord. Anyway, my lord, that paragraph 21, my lord. Next. Paragraph 21, my lord. That copy of the representation has been annexed as Annexure 17, my lord. Paragraph 21. That even after receipt of the said representation dated 10/12/2018, Annexure 17, the University Authority did not pass any order on that representation, but an order was issued on so-and-so 31/12/2018 by the Registrar in charge holding that the petitioner is to retire on 31/1/2019.
Continue.
Did not pass any order on that representation, but an order was issued on so-and-so, holding that petitioner is to retire on 31 January 2019. Be it stated that admittedly the matter of the date of superannuation of the petitioner was in dispute, as it reveals from the above noted various correspondences made between the University Authority and the petitioner, which is yet to be decided finally. As such, impugn order dated 31/12/2018 is a premature one and liable to be set aside. These two paragraphs,
You answered in 15.
my lord, two paragraphs, nothing about that inquiry report. His contention is not that this retirement order, this impugn order is followed by that inquiry report. In the context of this paragraph 15 has been, my lord,
Okay.
my lord, responded. Now paragraph 19, my lord. It is very important, my lord. I'll skip the paragraphs, my lord. The writ petition paragraphs 30, 31, 32, and 33. All these paragraphs is regarding that inquiry report. Now, what the response, my lord, in the affidavit by the Guwahati University? I'll read slowly, my lord. This is important. Paragraph 19. That your deponent denies the statements made by the petitioner in paragraph 30, 31, 32, and 33. Denies, my lord. And states that the petitioner joined Guwahati University as a peon in the year 1980, and he has served the office for about 39 years. Therefore, no injustice has been caused to the petitioner. The date of superannuation of the petitioner was calculated as per his own declaration made in the year 1980. That is, the date of birth of the petitioner was on 8/1/1959. It is most important. The writ petitioner failed to make out any case for interference by this honorable court. As such, writ petition is liable to be dismissed forthwith. This line, my lord. The date of superannuation of the petitioner was calculated as per his own declaration made in the year 1980.
That I have taken note.
So, my lord, paragraph 14, 15, and 19. In the context of, my lord, the writ petitions, paragraph 20, 19, 20, 21, 22, and 31 onwards, my lord. So, there are two different processes, my lord. And if he is aggrieved, my lord, my last paragraph of the written argument, my lord, he should have preferred an appeal under rule 52 or 53, my lord. As per printed version 53, it should be 52, my lord. So it's a service condition, my lord, date of retirement, my lord. So if he is aggrieved, my lord, he should have appealed, my lord. Clubbing together this only the technical aspect and giving primacy to only the paragraph 15. My lord, I don't think, my lord. Overall, my lord, it goes against SR 8C and also this rule 52 or 53.
Okay.
That is my submission. At least he should have preferred that appeal.
Heard, Mr.
ठीक है, गुस्सा
DK Goswami, learned counsel for the petitioner. Also heard Mr. PG Fugan, learned standing counsel, Guwahati University. Body. Respondents?
All the respondents.
No, not three.
Miller, 1 and 2 Miller, sorry,
One
sir.
and two. I will confirm.
Sorry, Miller.
That's
1 and 2. 3 is private respondent, select committee.
You arrange it for me.
Extremely sorry, Miller. I have taken so much time, Miller,
No, it's fine.
to clarify some points, Miller.
No, that's
Some
not an
elaboration
issue.
is required.
That's not much.
Item 1.
Normally, I give sufficient time.
Most obliged.
Order. Sanjit Das.
Meet please, Your Lordship. Your Lordship, this IAVF file for bringing before Your Lordship the recent developments which have taken place during the pendency of the connected writ petition. Writ petition, we have challenged the order dated 2011-2019, by which the respondent number 2 has rejected my prayer for provincialization and has allowed the private respondent. In spite of the fact that I am senior to him and that I have been serving in the said post since 2008, 31/7/2008. Thereafter, Your Lordship will find that on 19/5/2022, one advertisement was issued by the principal of the said college to fill up the post of library assistant under the UR PWD category. And I was selected there. And 2 years later, I was informed by the respondent number 2 that my approval has been rejected. Thereafter, subsequently, another advertisement has been issued. We have challenged that, and this honorable court vide the order dated 17/7/2024 has stated the that subsequent advertisement and the written test was also fixed on the same date. That was also stated. So one notification was issued on 7/6/2024, which Your Lordship will find at page 19
Of the
of
IA.
the IA. Now, why this notification? Your Lordship will find I am Sanjeev Das, number 1, serial number 1. I have been provisionally appointed for a period of 89 days in the post of junior assistant in the said college. Now, the last date is, Your Lordship will find in the last para, 28 August 2024. Now, all these events clearly goes on to show that they are trying to deprive me of this post of confirming me in the post of junior assistant in the said college. And
Junior assistant?
junior assistant comes this LDA come junior assistant.
No, the earlier this court
Yes,
directed that the result of the library assistant
yes, that will be stayed.
shall not be declared.
Shall not be declared. Yes, thereafter,
What happened after that?
after that, between that, on 7/6/2024, I have been given a provisional appointment.
No,
for
that's
it.
fine.
Yes.
Yes.
So now
that
I'm
is-
intending.
That is expiring tomorrow.
Yes, I'm
Ah.
intending that they may terminate me after that. So yeah, I want the I'm praying before Your Lordship that no coercive action should be taken by the college against me. Because this, if Your Lordship goes through this notification, this clearly says that the appointment has been made for 89 days only.
Now, you read the next line. If needed for
Yes,
smooth functioning of the office, there will be provision of reappointment.
Reappointment, but they may not reappoint me. That's why I'm apprehending that I may be ousted, because I have already filed this present writ petition and another writ petition challenging the subsequent advertisement and my cancellation of my provincial. So only this direction will do, that no coercive action should be taken by the college.
Yes, Tabilda.
Actually, I have received the brief just now, Lordship.
Hmm?
I have received the brief just now, Lordship, second copy. I was not aware of the matter, Lordship.
You've not informed him.
I have informed, I served the copy at 2 o'clock.
So it was served in the office, it might be served in the.
It was
we have
served in
not
the office,
received.
they've received.
So,
Such matters you should have served on the
yes, no,
councils directly.
and no information. Just now I have taken the second copy from the Lordship. And it's a college,
THB college.
it's the internal arrangement of the college and the Lordship, I have from the Lordship, the result of the record, it seems that the respondent number 6 have filed Lordship affidavit also in this matter. The private respondent.
Respondent number
The
Six.
private
in
respondent,
the writ petition.
in the writ petition.
Petitioner. So their presence will be also required, Lordship.
Respondent number 6.
Your Lordship will find is Ajit Bhuya.
Ajit Bhuya. Yes.
No. That is in WBC.
In
536.
WPC 536.
Oh, sorry, that is
2020.
2020.
Does not affidavit.
536 I also.
No affidavit. Lordship, not, no, I'm talking about Lordship, the Wakalatnama, Lordship. Wakalatnama.
Where?
Please hear.
Because only one order is there. This court had issued notices. That is in page 15.
No, 1 minute.
Hmm.
7536. Ajit Bhuya.
You know. Also, regarding listing unlisted matter, also they have to inform us. Also.
No, that's what we were saying. Maybe they've.
By 2 o'clock, we have served the.
No, see, these are unlisted matters. You should not, cannot just serve them on the clerks. You should serve them personally so that they are aware of something is, because these are all unlisted matters. Maybe in the morning hour, they are not present in the court.
Whole day, our friend, whole day they are there.
No, this is the problem that we are facing.
So only in regard to this page 19 notification.
That part also looking at tomorrow or day after tomorrow. Otherwise, no sick. We have no.
Page 19,
Page 19.
this is issued by the principal.
Principal.
Now, whether the principal copy has been served.
They have appeared earlier in the writ petition. And tomorrow is the last day. That is the problem.
If colleges appear earlier occasion, they have to serve copy of the copy to the college also, just because it's a old pending matter also, 2020 matter. Police appear holding.
College has appeared, respondent number 1 and 2, page 15.
College আমি নহয় না।
Yeah, 1 and 2.
কি college আছে? কি college? College তো কি?
THB.
Hmm?
Yeah, Hindu.
Please, THB appear নহয়। That's number 1, হচ্ছে higher education.
15.
1, 2, 3, আমি 1, 2, 3 হই।
যাতে আপনার 1 and 2 দেখে এই অর্ডার অফ 10 to 20. 1 and 2 না কলেজ হায়ার এডুকেশন ডিপার্টমেন্ট আচ্ছা কলেজ না কোর্ট
Even lordship, private respondent are also there and they are also appeared lordship.
Where?
In the Kukalanama here lordship.
No, the respondent six,
Lordship.
not the governing body.
Not the governing body, otherwise respondent number 6 also appeared as per the second file I have received of
Oh,
as per
that is the
court second file.
respondent six is there.
So lordship may posted the matter tomorrow if there are urgency lordship, otherwise lordship it will be difficult on our part to assist the court lordship.
Or tomorrow it can be taken.
Hmm?
Tomorrow.
See, this is the problem. This morning we permitted you
Yeah.
at 2 o'clock. It never came at 2. Look at your prayer. You want the order to be stayed 7/6/2024, by which you were given the extension for 89 days.
Or your lordship, alternate prayer is not to ask me from the college. It is another alternate prayer.
Why do you want to stay of this 7/6/2024?
No, that's fine. Mistake. That shouldn't. The prayer should have been not to ask.
I'll just say not to take coercive steps.
That will do.
If college council is lordship appeared, so lordship fix the matter tomorrow lordship.
No, the college council is not present even in the writ petition. Only the respond number 6. That's a private response.
Lordship.
That will do, your lordship.
Otherwise,
I'll issue notice.
otherwise lordship, if lordship regular selection is going on lordship.
No, regular selection, that advertisement,
Lordship.
so far as the library assistant is concerned, this court has passed an order
Lordship.
that not to declare the result without the leave of this court.
And if he is working private sector,
I'm working.
Now he is saying that he has been appointed by the 7/6/2024.
Okay.
His service has been extended for 89 days,
Lordship.
which is expiring tomorrow.
That part is there, otherwise it is not permissible lordship.
Hmm.
After coming to force of 2005 Act lordship, no college authority can appoint person or engage a person lordship. And non-sanctioned post even ad hoc basis also, even lordship 1 day also lordship.
But what about this 7/6/2024?
Here they appointed.
6 lordship, they have illegally they have given lordship. Illegally they have lordship appointed him lordship. That can permissible. It is the internal arrangement lordship.
They have also stated that I can be reappointed.
It is the internal arrangement lordship. Internal arrangement of the college authority lordship. If there is a requirement, the internal arrangement lordship, they can do lordship. Otherwise, lordship, it's a 89 days term lordship. If he is not ousted lordship, or he is not continuing lordship.
Any case, the appointment of library assistant has been stalled.
Well, lordship may only that order is there. Then lordship, he will no way prejudice lordship. After all, lordship, the extension part lordship, there is a financial issue is there lordship. If he is continuing lordship, then lordship, he have to pay something lordship. Without paying lordship, he
It's a government college.
Yes.
is a provincialized college.
It's a provincialized college.
Yes,
Provincialized
provincial.
So who makes the appointment?
The governing body.
No, Lord. It's a directorate lord.
This is the director
Directorate lord.
in terms of the rules.
Rules also.
So in fact, this is an illegal order.
Lordship.
Then can this court extend an illegal order?
Your lordship may only observe that no coercive action.
How can I pass that order?
Even lordship, in the eye of the law, that particular letter is not to be lordship treated as a valid.
If the director had issued the order,
Yes.
I would have asked the director not to take any coercive steps. Now, this order has not, I don't know whether it has passed with the knowledge of the director or not,
No.
or whether the director has any knowledge that this order has been passed by the principal.
Even
That is
lordship,
nowhere
time,
reflected.
even lordship, time and again lordship, you have instructed the college authority not to engage a person lordship. Time and again lordship. Even since lordship 2004 onwards lordship. Even 2023 also one notification was issued lordship. Then the particular governing body and the DDO will be responsible lordship.
Here 12 people have been appointed.
Exactly. Illegally. can I pass an order to extend this illegal order by this court? So I'll issue notice. After that, we'll see. Any case, so far as your post is concerned, that is not to be filled up.
Let us protect it as per Lordship's order.
Heard, Mr.
Yes, Doctor.
S. Data Learned Counsel for the petition. No, Learned Counsel for the applicant. Issue notice. You are appearing for?
See, I am for one and
Mr.
two.
K. Gogol, Understanding Council Higher Education appears for the opposite parties,
One and two, Lordship.
1 and 2. And district level scrutiny committee,
District level government, my lord may indicate Deuri's name, it reflect.
Mr.
with
D.
Deuri.
Deuri, Learned Government Advocate appears for the response number 5. The applicant to take steps for service of notice on respondents 3, 4, and 6 by registered post within 1 week from today. List this matter after 4 weeks.
Obliged.
Oh. When do you want?
After one.
Okay.
Date nine.
Item 27.
Yes.
Okay, on request made by Mr.
Hussein.
A. Hussein and counsel for the petition. Is the matter again on 10th
10th August. Sorry, September. Obviously.